Let's give this meeting of the abandoned. Try this one more time.
Muted.
And yet again.
There you go.
Okay.
Everyone should be able to hear you.
The meeting of the Abandoned and Discontinued Roads Commission for November 17, 2022 will come to order.
What's up?
Do I need that back, or can we
Oh.
unmute from this mouse?
You can, I'll give you the mouse back, but you would just, you would use your laptop to have people's unmute.
Great. Thank you.
No problem.
Just seeing Vivian's head.
They'll see, you can turn your video off if you want. And then the owl will just, mute it. It will follow anyone who's talking.
Very wise.
And you can, make sure this one's pinned.
Going for this one where Jim is?
This whole thing is one.
Oh, that one,
Okay.
sorry, I see what you're pointing
You
to.
might be able to right click on that. Or, this one, like, that's why. It should be all set.
We're going into session, I trust you.
All right, now that we have the technology under control, kind of.
Give me a call.
Thank you. We'll delegate to Vivian the calling of the roll for this afternoon's meeting.
Brian Bronson,
Here.
Corporal McCabe,
Here.
Pete Coughlin,
Here.
Ryan Pelletier,
Here.
Carla Black. Here. Rebecca Graham is absent. Kathy Neto. Yeah. Jim Katsiafikis.
Here.
John Monk,
Here.
Roberta Mancher. Here. Steve Young.
Thank you. Yes, here.
And I am Vivian McHale and I am here, so I'll turn it back over to you, Jim. Thank you.
Thank you. We have meeting minutes that were prepared wonderfully for the October 27th meeting. And do we have any changes to those? Any things that folks noted that they wanted changed in the minutes or thought should be changed? All right, seeing none, is there a motion to accept the minutes?
So moved.
Second?
Second.
Okay, thank you. All in favor? And we'll have to do this by a roll call vote, and I apologize.
Brian Bronson,
Yes.
Corporal McCabe,
Yes.
Pete Coughlin,
Yes.
Ryan Pelletier,
Yes.
Carla Black. Yes. Rebecca Graham is absent. Kathy Neto. Yes. Jim Katsiafikis.
Yes.
John Monk,
Yes.
Roberta Mancher. Yes.
All right,
Steve Young.
Yes, for me. And NARS bars is on also.
who is NARS Bars?
He's an observer from Main Roadways.
Oh, okay, so not a voting member of the board. Okay, thank you.
And I similarly vote yes, so the majority vote. Accept the meeting.
Sounds unanimous to me. Thank you. So one thing that we talked about fairly extensively at the last meeting is how do we advertise this commission's meetings, let people know what's coming up, provide materials for the public to review. And also just to, make sure that, there's the, maximum amount of participation by the public. We were talking about, trying to have an online presence. Maine.gov was basically saying $500 per month for us to be online with all the other state agencies that I don't know if they all pay that amount, but at any rate, we don't have it. And short of, as we joked about having a bake sale or whatever to pay for it, we don't have the resources either. So we had talked about that some, and Vivian had kindly said she would she would talk to the Office of Technology and information and get back to us. What do we have for some ideas?
I have a handful of ideas. I think we talked pretty extensively about MailChimp. We did talk about that at the last meeting. In trying to get final approval for that, it turns out that OIT does have some concerns with MailChimp. But I had follow-up discussions with OIT in my office as opposed to the OIT higher ups who they have a white paper on MailChimp and Constant Contact and why those create some issues for state use. I think that given our uses for it, specifically that everything we do needs to be transparent and there's no concerns with if anyone says we want every single contact made to you or that was outgoing by you, we would no problem turn that over, which platforms like MailChimp and Constant Contact make very easy to do. So they are revisiting that based on the conversation I had with my OIT lead in the AG's office to try to override whatever come from it was that made them say that that was not an option. So that is hopefully going to be resolved. I was able to get OIT to create a general email address for us that was of no charge that I haven't disseminated it to anyone yet because it's brand new, but it's info@abandonedroads. I'm not even sure what it is. I will let you know. But so once we figure out where we're going to live online, that can be a place where the public can send us requests. And hopefully that will be the email that we assign to a future MailChimp account where people can sign up to become interested parties and get all of our mail blasts, meeting notices, past recordings, things like that. Roberta brought to my attention in our last meeting, we had members of the public who tried to view it. And my mistake was that I created a waiting room, which meant that members of the public were not admitted at all. They had to wait to be admitted. So now everyone is in the waiting room. And participation will be by raising a hand and then being unmuted. Members of the public, their participation will be by invitation at certain points in certain meetings. So what I thought of to try to alleviate that is like legislative committees have YouTube channels. I've applied for us to have a YouTube channel. Strangely enough, because we're a new entity, the way that gets created and sort of verified as a real entity is you send in information online and they send you a postcard. And then the postcard gives you some sort of something code where you then, they say it's going to arrive in 5 days. It all seemed very like Willy Wonka to me. I don't know, but so I'm really working on that and I hope we'll have a YouTube channel so that we can then have, and then that's where all the videos will live and that sort of thing. Because as you saw from my email, the recordings that are generated when I use the state Zoom account are very locked down and are only viewable by people to whom I send them directly by email. With respect to hoping to try to prevail upon OIT in terms of an online actual website, not at the cost of $500 a month. That is also something that my OIT lead was going to look into as she looked into whether or not MailChimp is actually rather quite appropriate and safe for our uses. Short of that, I do not have any hard and fast next steps or forward motion. My OIT lead is on a very, very well-deserved vacation right now. She'll be back on Monday. So I hope to speak with her on Monday. So I'm working on it. If anybody has any more grand ideas, please let me know. Until then, we'll proceed as best we can The one problem with that is we need to get public notice out of the remote meeting policy. So far, everyone has been a real trooper in getting here, weather's gonna get bad, that sort of thing. So that's the one thing that gives me heartburn. But I think that's the long and short of it.
Vivian, thank you for your efforts in getting all of that done. Really appreciate that. Two things. The legislature does allow that remote policy to be adopted without without having a lot of notice, as long as there's some notice that it's out there. You used to be that you'd have to adopt that in person. You'd have to have a forum, everyone in person, and you'd be at the meeting and you'd adopt the policy. Now, so long as you give some notice, provide a copy in advance for the public to see, we can adopt it at the next meeting. So I'd suggest that when the agenda should go out 2 weeks in advance of the next meeting, and with it, a copy of the remote participation policy. And that should help take care of it. The other piece, and it's something I sent on to Vivian because I know it hits the $500 per month iceberg, but there are other commissions and committees that are standing committees created by Maine's legislature to look at issues on a recurring basis. One of them is the so-called Right to Know Committee, takes a look at the Freedom of Access Act. It's a standing committee of members of the public, municipal officials, state officials, and whatever, looking at the issues of the Freedom of Access Act. If you Google that, you will find that there is a homepage on maine.gov. And then from there, there is a web page on the legislature's website for that committee. We are created by the state legislature as a standing committee as well. We should have the same presence. We shouldn't have to be dealing with, all respect, the MailChimp. We should be able to have this on a state website if we're a state commission, and it shouldn't be costing anyone any extra money. So
Right.
we'll wait and see Monday what Vivian's contact has to say. We don't want to step over people's heads. We don't, we want to see what the response is. But if we can't get anywhere with that person, not that it's that person's fault, but just that's the way the bureaucracy works, then I think we'll make that same argument. I'll certainly be glad to that person's superior and see what we can do, because it's a state commission. It should be on maine.gov. They can link it to the legislature's website, but there should be a place where you can find our notices, who we are, our materials that we're starting to collect as part of the process, the reports that we'll be issuing, that should all be available to the public easily. So just some thoughts.
This is Vivian. I agree completely, and I'll report back on Monday. With respect to the remote meeting policy, I agree that getting it out 2 weeks in advance or even a week in advance, as you and I had talked, if I get a copy of it out, or you and I in concert get the agenda out by, say, December 1st, which is 2 weeks in advance of our next December meeting, I'm not what am I missing in terms of my concern that that's not getting notice out to the public?
Well, I mean, if we were a municipality, I would be advising that at least 7 days in advance, you put a legal notice in the newspaper. What we could do is, there's a consolidated notice of rulemaking that's published by the state of Maine on a regular basis in the Kennebec Journal for statewide publication. And what we could do is publish in that statewide rulemaking notice a notice of this board's meeting.
Okay.
And we could even put our agenda in it and that way it's all out there in advance. The other thing is, I'm hoping that with that agenda and with the remote participation policy, and this really gets down to 7 on our hit list here of things to do today, but it would be a good idea to tell people what the public hearing that there will be a public hearing on the 14th and what it will be about, what the issues are, what we'd like to have people speak to that's within our jurisdiction. That way, each group that many of you represent can put that on your website. And so the public can see it that way. If we can't have our own website, it'll at least be on our members' websites. So that's why I think getting the agenda ready a couple of weeks in advance, along with the remote policy, and also having the agenda and what it is we're looking for at the public hearing will help get as much comment into us. This is going to help our job. knowing what the issues are and how people feel about those issues. Does that make sense?
It does, what I was told, I think Chris was told the same thing by our departments. You know, people, is that we should be pointing to. Rather than trying to copy and paste and whatever, so obviously one, standalone website makes sense. Is the $500 a month issue the issue, because this is gonna be forever, it's gonna be on there for the next 5 years, or is this gonna be a website's only gonna be up for a few months?
Well, we're all appointed to 3-year terms, as I recall, so
It's gonna be more permanent, right?
Right.
So that's when it starts to really run up.
And we are a permanent commission, and it's annually and thereafter is the charge, so. I don't understand the $500 a month charge myself,
Right. Given that it's a legislative thing, it should be tied to that. Can't you fix that?
Me.
I hope to find out more. Maybe there'll be some like great moment where they say, oh, that doesn't apply to you guys. I mean, that's what I keep hoping for and haven't yet, but I'll
waiting
keep
for that breakthrough moment.
No, yeah,
We'll hope it happens Monday,
we will hope that,
but if
right?
not, we will follow up.
Yes.
But in the meantime, if we don't have a site for you to point to with your individual sites, we will ask that you try to put that up on your own site if you can. All right, so for today's meeting, I thought it might be useful to just go over road law a bit. Yeah, this sounds really exciting, right? A short history of road law in Maine on municipal roads. What could go wrong?
Yes.
Thank you.
I got it. What's that?
Does everyone have a copy of today's agenda? You have extras, Pete? No,
I didn't have.
I have it right here that you can look on. Okay. Do we have enough copies for everyone, or you need some more?
There's an extra.
I do not want to copy of those.
I don't even, because you're saying.
Oh,
So, Pete Coughlin and I used to do training programs for municipal road workers and for MDOT road workers, and so, he's probably heard too much of this already before. I'll try not, and he's also heard all the bad jokes too, so I'll start off with that. We talk about 3 types of roads that you commonly find in municipalities, and as the joke goes, they're paved, gravel, and mud. But, in reality, we're gonna talk about townways, public easements, and private roads. So when you talk about a townway, what we're really talking about are the town streets, city streets, town roads that you find in municipalities throughout. And it's also the roads that used to lead from county to county and in counties, because all those county roads became townways, at least within the organized areas of the state back in 1977. So what is a townway? Well, the state law says it's an area or a strip of land designated and held by a municipality for the passage and use of the general public by motor vehicle. It's all town or county ways not discontinued or abandoned before July 29, 1976. And it's also all state or state aid highways that are classified or reclassified as townways. The state has the authority, and DOT has the authority to reclassify highways as townways, and it's supposed to put them in good order before they turn them back and make municipalities responsible. The important thing about this level of road and townways is that there's an obligation on the part of municipalities to keep them safe and convenient for passage by motor vehicle. And municipalities are also required to plow snow from those roads, to clear them. Doesn't mean they're always going to be able to keep them totally free of ice and snow, but they're supposed to plow them. And the municipality has liabilities along with those responsibilities. If the municipality becomes aware of a defect in the road, something like a pothole, we call it pothole law, but it's a Highway Defect Act. If the municipality, by a municipal official, a select person, or a counselor, or a road commissioner becomes aware of a defect and has at least 24 hours notice, then anything that happens after that point, the municipality is potentially liable for property damage or personal injury up to certain limits under state statute. So under the Highway Defect Act or the pothole law, there is liability for defects in the road or want of a railing, but municipalities are on the hook for that. So they're responsible to keep roads safe and convenient for passage by motor vehicles, make sure they're maintained properly and are safe and are plowed, and they're also responsible to keep them free from defect that they become aware of. And it could be that within that 24-hour period, they don't have time to go out and actually fill the pothole, but at least put a cone over it or something to protect the public from injury. Do you or I have the right to go out and fix that pothole in the street? No, that's the municipality that has the right to do that, the sole right to do that. That's not something that abutters can or should be doing. Because if you do it wrong, you're creating more liability for the municipality in part. So that's the higher classification of roads in municipalities. Those are the streets, the roads that we all know about. There's a lesser classification. It's called a public easement. It's defined by state statute as an easement held by a municipality for purposes of public access to land or water not otherwise connected to a public way. It also includes what we used to know as private ways, or private ways subject to gates and bars. And that goes back to the old construct under Massachusetts law, where if you were a farmer, you needed to get your crops to a public way and into town, you would give some land to the town, a strip of land, and then the town would accept that, and that would be a private way. The public could use it, but it was subject to gates and bars to restrict passage. With regard to a public easement, a town has the right, but not the obligation to maintain it. So a town's obligated to maintain a town way. It is not obligated to maintain the public easement, but it has the right to do that. So if town meeting decides we're going to do winter maintenance on public easements this year, or these public easements, or these parts of public easements, town meeting can do that. The town or city council can do that, but it doesn't have to. As for liability, there's no specific, the Highway Defect Act does not apply to public easements. So the safe and convenient for passage by motor vehicle standard does not apply to public easements. There's no obligation there. Private individuals who property abut that public easement can maintain it. They can do work on it. That's generally, the holder of an easement has the right to do work to make that easement usable. And also it's been held by the state Supreme Judicial Court that so long as their exercise has a reasonable basis and is within the scope of the prior public use, the individuals abutting those ways can maintain them. The issue may occur is that if somebody is maintaining that public easement and may be negligent or use materials that are not appropriate or whatever, and someone is injured as a result or property is damaged as a result, they may be personally liable. I think that's a concern that folks, at least one member of this panel has expressed before. And so with the public easement, the abutters have the right to maintain or repair, but they perhaps do so at their own risk. The third type of road that we find at the municipal level commonly.
Could I?
Sure, please. Right.
I happen to live on a public easement. One of the questions I had, and I don't know if you're gonna cover it under the next section or not, but what changed sometime in the last, time-wise, 10 to 10 years, I'm gonna say. We got the public easement adopted at our town meeting like in 03 before the change in law. For the very purposes that's spelled out here. We wanted the town to help with maintenance and all of that. Somewhere along the way, the law got changed, and I don't see it updated in the, I'm assuming this comes mostly from the manual, or a lot of it. You wrote the manual, I know, but has the manual been updated?
Yes.
To include the changes in law that allows public funds to be spent on private roads that are under the jurisdiction of road associations?
All right, I didn't add that wrinkle in.
Okay,
I didn't know those
But
private roads.
does it fall under our purview to have that discussion or not?
It isn't part of the abandonment or discontinued part. That's more of a question of private road associations and what their authority may be. But it's a wrinkle that's worth adding, so. There may be an updated version of this that winds up being part of the material, so. Good point. What we're trying to stick to, since we're the Abandoned and Discontinued Roads Commission, is working on those public easement issues that arise out of abandonment or discontinuance. But there are some other things that we need to keep in our minds as we're looking at these issues. So with regard to private roads, a private road where there are no public rights, it's not a public easement, it's not a town way, it's never been accepted by a municipality, it's never been discontinued by a municipality. It is simply a private road. There is no right for a public body to be spending money on private roads. To do so would violate what's called the public purpose doctrine of the state constitution, which says that you can't take tax-derived revenues and spend it for private purposes. And so, for example, the road commissioner may get that call of, the VFW wants to have their driveway to their parking lot plowed, or the church wants something plowed, or these are all private roads. You can't, or individuals' driveways. You can't plow the private roads with public funds and public equipment. That's a violation of the state constitution. And also could open up folks to liability because it's really beyond their authority if they're doing that work. So townway, the obligation to maintain, and liability for failure to maintain. Public easement, no obligation to maintain, the town can if it wishes to. Private road, the town has no right to be there, shouldn't be there generally, so those are the three levels of roads that we typically find on the municipal level of government. So we're concerned with abandonment and discontinuance about terminating public road rights. Maybe it's worth taking a look at how they're created in the first place. So that's right here in this manual, in this presentation. Really three ways that you can create public road rights. The first is dedication and acceptance. How many of you have been on planning boards? Okay, how many of you have been to planning board meetings? All right, so you know what happens when they're redoing a subdivision, right? You get this big 2 by 3 foot Mylar. It has lots carved out on it, and it has roads shown on it. When that's recorded, that's a dedication of rights in the road to the municipality. It's a gift, an offering of those roads to the municipality. And if a lot sold in reliance on that recorded subdivision plan, there is a right of the part of the municipality to accept those roads. Most towns and cities aren't going to accept those until they're built to specification and accepted and acceptable. And then there is acceptance. That's the legislative body. When I say the legislative body, if it's a town meeting is the legislative body. If it's a council town where the council has legislative authority, city or town council, that's the legislative body. So a road has to be not only dedicated, and it can be by a gift, give you a deed to the road, where it's shown on that subdivision plan and recorded. It has to be dedicated, and then it has to be formally accepted by the municipality. And we recommend that there be a deed for that road, not just show it on the plan, but there actually be a deed to the town or the city that can be accepted and then recorded in the registry of deeds, so that everybody knows the extent of the rights, the bounds of that road, and you're not just relying upon a plan. So dedication and acceptance is one way. Another is laying out and taking, and that can be by purchase. And you agree on a price with the landowner, and you go out and buy the property and then accept it. Or by eminent domain, which is where there's a public need for that particular segment of road or that road. And the public is going to use it, it'll be open to public use. There's a necessity to take it. the property owner won't give it to you, won't sell it to you. If there's necessity, if it's for a public use, then it can be taken through eminent domain. That doesn't mean you get it free of charge. You have to pay just compensation for fair market value for that property. So eminent domain, purchase and acceptance are two ways of laying out and taking a road. Eminent domain is something that municipalities, state government, county government do not want to use. That's their last resort. But if they can't buy it for a fair price, or they can't buy it at all, and it's needed for the public and it's going to be open to public use, then the governmental body can acquire it by eminent domain, pay fair market value plus any severance damages to the remaining land. When the check passes and the order of condemnation is recorded, it owns it, and that's it. It should also be accepted at that point too. So these are ways in which there's a document, there's a deed, there's a dedication, there's an order of condemnation, there's paper to back up that there's an action to take those property rights. But the third way to create a road just happens. And it just happens because of long public use that's called prescriptive use. You've probably heard of first possession of land, where basically if you use land as though it's your own under a claim of right, maybe pay the taxes on it, use it, it's open, it's notorious, adverse, for 20 years or more, 20 consecutive years or more, you can acquire that property, you can own that land. Well, there's a similar right to acquire an easement. It's by prescriptive use, not adverse possession, but it's called prescription. So basically, a municipality has to show that there's been continuous uninterrupted use by the general public for at least 20 consecutive years. It can't be with the owner's permission. It has to be absent permission, under a claim of right, adverse, open, notorious, visible with the owner's knowledge and acquiescence, where acquiescence is presumed because it's so open. That use can lead to a road becoming a town way or a public easement. What it becomes depends upon the nature of the use. The size of the road, at least initially, is depending upon what it's been used for, but it can actually increase in its use, level of use later, because it's a prescriptive use by a municipality. So there are three ways then that you create road rights. You can purchase and accept, you can have an eminent domain through layout and taking, you can have dedication and acceptance, and you can have the prescriptive use. Again, the prescriptive use can be a little problematic because you don't know when it arises. There's no clock out there saying, oh, 20 years have passed. And so that can give rise to litigation in the future when people dispute whether or not there's actually been a prescriptive taking of that lot, of that road. But at any rate, it is a way in which municipalities can acquire those road rights. So once you have those road rights, it's great. The municipality can use the road, but it has the responsibility to maintain it and the liability if it doesn't. What happens if there aren't enough people living on a road, or the road isn't used enough to justify continuing it? Especially if there are problems with the pitch of the road, that may be that there's too great a grade, and you would build a road like that today. If you were to do that, it's too hard to maintain. A municipality may want to terminate its road rights because it wants to limit its liability. And so it can do that in a couple of ways. The one that we're probably most familiar with is called discontinuance, and that's a formal process. It's an affirmative process. It's done by the municipal officers initially, and then the legislative body. It's a process that's provided for by state statute. And it has become a little more complex because of relatively recent statutory changes. Generally, you go to it could be initiated by the town, it could be initiated by petition of landowners who don't want a town way there anymore. And so the municipal officers will send out a notice to all the abutters on the road that we're thinking about discontinuing this road. And we're going to have a hearing, and this is the date, time, and place of the meeting on this. We'll talk about it. We're proposing, and at that meeting, to talk about damages. You know, how much are we going to discontinue? Is it the entire road? Is it portions of the road? What will we pay for damages to the abutters? Because you're taking a right of public access from them when you're discontinuing it. And then that goes, there's an order of discontinuance that's entered by the municipal officers, the council or the select board after this meeting. Then that's referred to the town legislative body, the council or the town meeting, to determine whether to approve the discontinuance and to appropriate the money to pay the damages. When all that's done, the check is cut and the certificate of the discontinuance is recorded, and that has happened. So that's the process. At least that's the way it used to be. The process is now a little more formalized and a little more detailed. That process started back in 2016 with some changes to the legislation. And as there have been some more recent changes that took effect in October of 2018. The notice that's sent under the 2016 changes included a requirement that the notice of the order of discontinuance specify whether a public easement would be retained. And if it was proposed to be discontinued, then that was supposed to be stated explicitly in the order of discontinuance. After October 2018, that notice now becomes a little larger. The municipal officers who are going to send out this notice have to include information about the potential discontinuance, whether there's going to be a public easement retained, what the maintenance obligations are, what the access rights will be, what the rights of the abutters to enter into a private road association to maintain that, and the ability to go out and get private easements. So basically, in order to do a discontinuance now, the municipal officers, the town council, the city council, or the board, the select board, are going to have to be giving legal advice on all of these points to abutters in the notice, the potential discontinuance of the town way.
How did that become law?
Same way they all do. Some people brought issues up and went to committee, and this went through. So this notice now becomes a lot more detailed and has a lot more components on it than it used to have. And I think there were concerns about access rights, about how people's rights were being affected by this that resulted in these changes being made. If the only way to get to the properties that abut that road that's proposed to be discontinued is a public way, is the public way, then the select board, the council has to wait a year before taking action on that order. And that's to give time to the abutters to work out private rights to see if they can obtain private easements. Typically, if you live on a city street or a town street and you've got a deed, it will probably say, you know, Jim Katsikas, 61 Deepwood Drive. That's where I live. I'm on a public street. My deed doesn't say, and you also have a private easement. There's no backup. I live on the street. That's my access. So if you take that street away, I don't have a private easement to get to my property. And so that was the idea why, since 1965, the effect of a discontinuance is the automatic retention of a public easement, so that you're not landlocked, because it is possible to have a landlocked lot in Maine. We don't like it, but it is possible. So that's why there's the automatic retention of a public easement and a discontinuance that happens after October 1965. This continues the retention of a public easement in a way. It has to be mentioned, but it does allow that the public easement might not be retained. It has to be stated explicitly now if that's going to be the case. And again, there has to be that 1 year given to the individuals, the abutters, to talk about obtaining private easement rights if that way that's going to be discontinued is their only public access.
Jim.
Yep.
I'm trying to put this into reality. for me,
Understood.
Okay, so you live on your street and it becomes discontinued and, okay, I get the education piece, that's all good. But doesn't the property still, the road when discontinued, still revert back to the abutters?
It will revert, and that's exactly right, but you're reading ahead, but no, right, that's fine. I'm kidding, yes. If there's a public easement, that stays with the town, if that's retained.
Yeah.
And all the other rights in the road to the center line go to the abutters. If there's no public easement, everything, the fee, everything goes to the abutters to the center line.
And so that's the 1 year piece where those people that are now owners of what is the road work out an arrangement so they all have equal access to get from start of the road to the end of the road.
That's right. If there's going to be no public easement, then those folks have a year. And so the municipality basically has to put the discontinuance process on hold for the year. Unless they decide, oh, well, under those circumstances, we'll give you a public easement. They put it back in again. Or sooner than a year, everybody works out their private arrangements, or there's some, lawyers have reported back to the town, everyone has an easement right, we're good to go.
I gotta ask the question, is it really common that this happened? That it needed that level of like, did the law have to be changed? Like, was it rampant across the state that municipalities were doing this?
I think we're gonna hear about that in a little while.
Yeah.
We'll hear next. So I'm not trying to make any editorial comments. I'm just trying to describe what happened.
Okay,
And then
and
we'll,
you'll talk about it happening? Okay.
so when we talk about the effect of a discontinuance, as Ryan pointed out, it used to be that before 1965, there would only be a public easement retained in the discontinuance of the town way if the order explicitly, specifically said there will be a retention of a public easement. Back then, it would have said a private way subject to gates and bars. After 1965, that presumption was flipped, and it was flipped in order of a bias in favor of retaining a public easement so that no one's rights would be cut off. There would not be a landlocked lot. A public easement would be retained unless it was specifically not done so. And that's the way the law has been. The wrinkle in the recent changes is that instead of it, you still have to specifically say you're not going to keep a public easement, but the issue of whether to keep a public easement is on the table in the notice and in the statute. So it takes away a little bit away from that automatic retention of a public easement by the discussion that's in there. There still have to be damages paid. If a public easement's retained, you're not taking all the public access, and so it's likely that it's going to reduce the amount of damages that would be owing if you took everything. So, but damages, again, is fair market value of the property interest taken. There's a right of appeal within 30 days. You can appeal the public need or exigency for the taking. Within 60 days, you can appeal the amount of damages. This goes to the Superior Court. Well, I've mentioned a little bit about utility easements here, but that's a little bit off the beaten path. So what we've talked about is discontinuance. It's a formal proceeding provided for by state law. There is a recorded history. There'll be notices. There will be an order of discontinuance. It's adopted by town meeting or by the council, and then there's a recording in the registry of deeds. So that's a formal process. Another way to get rid of public road rights is abandonment. And abandonment is not a formal process. It just happens by passage of time and failure to act. Two types of abandonment can happen under Maine law. One is common law, judge-made law, case by case. This isn't a statute. It's simply, it's something that's been done by judges under Maine law for years. What this means is that for some period of time, if the general public stops using a road anymore for some period of time, then there no longer is a town way. There no longer is a town obligation. How long is it? Well, it partially depends on how the road was created. where there's a town way created by prescriptive use. Failure of the public to use the road for 20 years or more has been enough to say there's no longer a public road right. Where a town had been, formally created a town way, and the public had stopped using it for about 100 years, that was deemed to be enough in another case. So how long is enough? We don't know, it's case by case. But there was a case in 1997 involving the town of Skowhegan, where the Superior Court found that 20 years of public non-use was sufficient to cause common law abandonment of that road. So at least 20 years, I would say, of the public not using a road, and it's the general public not using a road, is enough to result in the abandonment of that road. It no longer is a town way. But as you can see, that invited litigation. Because as 10 people have used it, well, 15, well, the UPS driver used it, well, the oil truck went over it. What's enough, what constitutes public use? And who's out there with a camera for 30 years or 20 years? You wind up having to talk to people, take depositions, and have a number of witnesses in order to try to make a case. And a trip to Superior Court these days costs tens of thousands of dollars. And there's always the uncertainty and the time that goes into that. So the legislature's taken a look at some other ways to try to address that. So we have what's called statutory abandonment. There was an early attempt at coming up with something like statutory abandonment as an alternative to litigation of the common law doctrine of abandonment by non-user. Back in 1968, the legislature enacted a statute to create limited user highways so that towns, cities, the county could take a road and say, this is a limited user highway. We don't have to maintain it. We don't have any liability. There'd be a public meeting where this was discussed, but that was it. And so if your road was put in this category, you basically would have lost your public road rights. You wouldn't have a town way anymore. It would be, the city of Portland coming up to me saying, Jim, sorry, you live on a limited user highway. We're not going to be plowing your road anymore or maintaining it. And sorry, we're not liable for anything. There's no Highway Defect Act claim that you can put for the pothole in front of your house. We're done. Have fun. The city of Portland would never do that. But I'm just saying that that's the concept. You could be dropped into this category. And what would happen is my public road right, my access to a public road would have been taken away without any compensation, without a hearing. And the law court, State Supreme Judicial Court, determined in Jordan v. Town of Canton that was unconstitutional. That was a taking of property without payment of just compensation, because we're taking your right of public access to that road and from that road to the nearest public road. It's gone. Now, it's one thing to discontinue and pay damages. It's another thing to have a statute like this where there's no right, there's nothing, and suddenly your rights are gone without any payment of compensation. So what the legislature did was, in 1976, pass a law that created a statutory presumption of abandonment. If the town or city did not spend money, public funds, to maintain the road or a portion of the road for 30 consecutive years or more, then there was a presumption that the road was abandoned. And if the select board or the council in good faith determined that this road was subject to that presumption, then they didn't have to maintain it. They would not be liable for failure to maintain the road. What this also said is that an abandonment like this had the same effect as a discontinuance, which meant automatic retention of a public easement. That was passed in 76. It stayed in that form pretty much for about 25 years. Then what happened is people were allowed to appeal the determination of the select board or the council to the Superior Court directly. Until then, what would happen is you have to file a declaratory judgment action in Superior Court if you wanted to contest that determination of the select board or the council in good faith. So this is an informal way. It just happens over time. The town stops spending money for some period of time, which is an indicator of public use. You wouldn't spend money to fix it if the public isn't using it. So this statutory abandonment is sort of a codification of the common law doctrine of non-user. It's just the measuring, the objective measure is the town spent money for 30 consecutive years to fix the road. Presumably, if the public were using it, they'd have to spend the money. If they weren't spending money, then the public must not be using it. We're going to presume it's abandoned. And then the burden is going to go to an abutter to bring a case in court and say that the town did spend money. The town did more than just isolated acts of maintenance. Maybe you might argue that it was graded every year, it was plowed every storm, and then the burden shifts and the town could lose at that point. If money has been spent, the municipality or county received funds for any portion of the town way for 84 months or more out of the 30 or more consecutive years, then that beats any argument that that road is abandoned. That's a new change in the statute as well. So the status of the road after the abandonment up until recently was that it was just like a discontinuance, and there's an automatic public easement retained and the abutters owns the center line. Under the statute as amended in 2021, it's a new discontinuance statute. The municipal officers have to send notice. They have to many of the same things they have to do for discontinuance, let you know about your rights, your right to form a private road organization. And the municipal officers can decide in that order that determination whether or not a public easement should be retained. So it's not automatic anymore. They make a decision as to whether it's retained. It has to be stated explicitly if it's going to be not retained, but they make that decision. There've been a lot of changes to the discontinuance and abandonment laws since in the past 6 years, in 2016, in 2018, and then again this in 2021. We're still working through those changes. I think we'll still be seeing court cases arising from those and exploring some of the wrinkles in those. But that's basically how we got here in terms of the law. I'm trying to avoid any judgments on those and what they mean. I think people have their thoughts on how those apply, why we're here, what those are intended to fix, and what some of the problems might be. That's just a broad statement of the law in this area. Be glad to try to answer questions that you might have. And then after this, I think Roberta Manta has the floor for her presentation on some of these issues as well. Any questions for now?
I'm trying to understand one thing, Joe, on the discontinuance of the 30-year thing. You know, a lot of roads in Maine came to be not really formally adopted by anybody, you know? They were farm roads maybe, and over the years, farmers went to the town and said, hey, I want this maintained, and they agreed to it, whatever, but never went through the formal process. Does the 30-year thing apply to all roads regardless if they were legally created or not?
Well, if they're town ways, then that would apply.
Even if they weren't created as town ways by formal adoption like in 1900?
Well, that's an interesting question of how were they actually acquired? Were they prescriptive roads because public has been using them for a long time? Or maybe they were the old private ways where the farmer went to the town and said, you accept that? Well, I need to get my goods to market. But for those that are town ways, that's how the abandonment applies, and the presumptive abandonment, the statute applies to those. It's one quick war story. I was representing the town of Livermore, and they had a road that went from Livermore to Canton, and roads that went from town to town were laid out by the counties. So a portion of this road was discontinued by the town of Livermore. But in order to find where was it established, I'd go back in county books back in the 1800s try to find out, and it wasn't to lay out the X road from Livermore to Canton, it was the road from so-and-so's house to so-and-so's farm by the tree. These properties have all changed hands 10 times since then. You have to get a title abstractor to go back and see exactly whose properties these were. And that's why these are all fact specific. They're all expensive and time consuming to litigate. There's a lot of uncertainty. Anything that, in my opinion, anything that we can do as a state to make it easier to try to determine these rights and would be helpful to the process. And something that's easy, but also it will give you a good result, a fair result. I don't know if that answered the question, but it's certainly an interesting area of law. So with that, I'm sure questions will come up as we go through, but that was just to try to get us all on one page on those terms. Roberta, you ready to take us away on?
Yes.
Okay, thank you.
My problem here was trying to figure out how to boil 50 years of frustration over our road. A whole state full of people who've been submitting their complaints to me for the last 20 or 30 years into whatever time you can allow me to. I have a map at home that's got pins all over it, from one end of the state to the other. It's just one pin per town where I've identified a problem road. And a lot of these towns have multiple problem roads. So I'm going to do my best to try to condense things if I can. I have two handouts here. The first thing I did was I thought, well, I need to quantify this somehow and figure out what other people see as being the most important issues, because this isn't just me, this is everybody. So what I did was I made up a survey on SurveyMonkey, which allowed me 40 responses for on this free survey. And within 6 days, I had my 40 responses. I've been getting on average about one new complaint per week for the last year. And this is not counting the old complaints that keep coming back up again with new issues that are still struggling through the old issues and not finding answers. So anyway, I sent out a survey, and the first handout I want to give you is a copy of the survey itself, so you can see what I asked people.
Roberta, the people you asked are members of your association?
Excuse me?
The people that responded, members of your association, or?
What I did was first I just posted it on the Main Roadways Facebook page.
Okay.
And I got a trickle of results coming in. So I thought, well, I've got to call people's attention to this more. So then I went down my list of email addresses for people who have contacted me in the last year, for whom I have email addresses. Some of them I don't. Some of them I'm only in contact on Facebook. Some of them are things that I saw on the news and I haven't actually had contact with the person. But I sent out emails to the people I had email addresses for, and I got a burst of new responses. And then I also sent out messages on Facebook Messenger to people that I've been in contact with on Facebook, and I got another burst. And so I said within 60 days, the 40 responses were full. There were certain issues that really jumped out, and I've got another handout here. Okay, and this one, I guess we're not quite ready for this handout yet, because this is some of the solutions. Some of the issues that really jumped out were the constitutionality of having roads that are open to public use, but the public doesn't have to provide any maintenance. That seemed to be the real biggie. And I think, let's see, did I want to copy it? No, I think I passed them all out. Is there an extra someplace?
Well, there are extras right here.
Yeah, no, I was gonna say, I thought I passed out, printed off more than I needed. Okay, Where's the one? Okay, so the results of the survey, the two top winners for top priority, 77.5% of the respondents, 31 out of 40, gave 2 items of 5 for extremely important. The first was constitutionality of public roads with no public maintenance, i.e. private citizens being compelled to bear the cost of maintaining public roads, and problems figuring out the actual legal status of the road. As you said, this can be very complicated, trying to track down, where Smith's Barn was, which where the road started or ended. Close second, 75% of respondents, 30 out of 40, gave a 5 for top priority to defective or ambiguous action by the town or county leaving the legal status of the road uncertain. And this, again, is kind of tied into that second one. Then the next highest priority, 65% of the respondents said prohibitive cost of litigation. As you mentioned, again, that can be tens of thousands of dollars more. And then I went through again and combined the number 5 and number 4 ratings just to see how that would come out. And the results were similar, a little bit different, but problems figuring out the actual legal status of the road, 92.5% of people put that as either a 4 or a 5. Defective or ambiguous action by town or county, 90% had that as either a 4 or a 5. 3 more issues tied for 3rd place. One is the constitutionality of public roads with no public maintenance, prohibitive cost of litigation, and lack of information or faulty disclosure of information about the road status given at the time of sale. And each of those items got 82.5% rated as either a 4 or a 5. So those are the most critical things as far as numbers of people finding that those are problems.
Roberta, can I ask a question?
Yes.
On the constitutionality of public road. So you're talking about a legitimate public road that is, it is a known town way. And there is no maintenance being done on the road?
Okay, what I'm talking about is public easements. So these are roads that were on time a public road, either a town way or a county way, but they were discontinued or abandoned under one of the laws that retained a public easement.
Oh,
So the public still has free use of that road, but they have no obligation to provide any maintenance.
okay.
And I like to joke that Maine Roadway's motto is build a better public easement and the world will beat the pathway to your door. Because what happens is when you have this road that people know is open to the public, they have a right to use it. But a lot of the people who are using it, in a lot of cases, these are through roads, and that's part of the problem. Back when the statutes first allowed laying out of private ways, the process for laying out a private way was that usually the request was from a landowner of improved land whose land was not yet connected to the public road system. And that person could go to the town and petition to have a private way laid out so that he could get people to his mill or he could get his products to town. And if he first went to the other landowners and the landowners said, no, I'm not going to give you a right to cross my land, he could then go to the town and the town could say, well, we don't have a need for a town way there because it's mostly going to be serving you, but there is some public benefit in having a road so people can get to your mill. Yes, we will lay out a private way. And the person who requested it was responsible for paying the damages. And it doesn't say anything about who is supposed to maintain it. Presumably the person who needed the road was going to maintain it, but back in those days, what did it mean to maintain a road? Basically it was cut the trees down and maybe level it a little bit and that was it. So there wasn't a huge cost involved. But that has evolved into what we now know as public easements. And public easements, as opposed to these private ways, the private ways were invariably dead ends because they went to a property and stopped. And now we have roads that used to be through roads, and at some point the town or the county discontinues it, but keeps the public easement, and the public easement is still a through road. So you have people who don't own any property there, who don't have any particular interest in keeping that road passable, but they can go in and say, oh, it's a good place to go mud running, and just drive through and leave.
And so
And
that's
don't
what
care
this is
what's
talking
behind it.
about, is roads that have been discontinued formally and that public easement is retained.
Yes, those are the biggest problem. There are some other ones, but those are the roads that are the biggest problem. We also have roads where the road was discontinued with no easement retained, and that's another whole problem because some people can be totally landlocked. So, anyway, I
Are
think,
sorry, just gonna ask
Sure.
questions. Are they landlocked? Does that happen commonly when they're already there? Like, they've already got their, they built their home, let's say. And then the town decides to discontinue and then they're left landlocked?
that doesn't happen now because of the clause in the discontinuance law that keeps public easement to keep people from being landlocked.
Okay.
But back before 1965, before they changed the law, what the law said was that when the road was discontinued, it was gone.
Yeah.
And there were exceptions, which I have my doubts about. The courts have said that if the discontinuance order specified that a private way was retained, then it was. If they didn't specify that, then it wasn't. I don't see anything in the law that allowed them to do that. I'm kind of glad they did, because otherwise we would be landlocked. But the question is, can you come back in our case, in 1983, our town attorney told us that the road we were on had been discontinued in 1945. That was before 1965, so there was no easement and we were landlocked. And we said, well, wait a minute, if we're totally landlocked, can we get our taxes reduced because we now have no access? We're gonna have to go to the other property owners and go through court to try to get an easement. And they said, no, we're not gonna lower your taxes because you live on this road and the road gives access to your property. We said, wait a minute, you just said there wasn't any access. And then they claimed that, well, the attorney said he changed his mind because there was a clause in there that said it was kept as a private way. And that went through court, and the court said that term private way was the same thing as a public easement because of a change in the law in 1965, which applied to a 1945 discontinuance.
So does that access revert back to the last property owner where the private way starts? So you would have to go through civil litigation with that subject that owns up to that spot where they discontinued the road.
They discontinued the whole road for 1.6
But the road's
miles.
still there, is what I'm saying. So it's like technically you're not landlocked. So who does that revert back to that you would have to go through civil litigation to get access to your property?
If it was discontinued without easement, then it becomes a little patchwork of private property. So, you know, the two people at the beginning of the road each owned the center line, the next two people each owned the center line, the next two people each owned the center
So
line.
everyone would have to come to some.
So the
type
two
of
at the end can
resolution.
get in, but nobody else can.
Yeah.
And,
Unless everybody came to a resolution,
right,
which never happens.
right, which is why I pushed to get that change through in the discontinuance law, saying, get the landowners together and see if they can agree on giving each other access.
The 1 year thing.
Yeah.
The 1 year.
Yeah.
And it's obviously common with a lot of remote camps and stuff that are on these old roads and stuff that were prior to 1965.
What often happened was that there was an old farmhouse and the family that lived there died off or moved away, and the town says, well, now we don't have any reason to keep the road open. And they just let it go, or they officially discontinued it, one or the other, either abandoned or discontinued. And then the children or the grandchildren who still own the property say, you know, we'd like to have a place where we can go out in the country, or, you know, they want to get away from the city and move out, homestead or whatever, or the property is sold. A lot of times where you see people moving into on these roads, it's somebody that doesn't have much money to work with. And they just want a place to call their own, and they look around for land that they can afford. And they find this lovely secluded little spot out in the middle of the woods, peace and quiet and nature and everything. And it's cheap. And so they buy it, and then they find out what they've gotten. And so this is where a lot of these things happen. That's why a few years ago, the real estate, the Association of Realtors, I guess it is, we're putting through a bill that said that in the real estate disclosures, when a property is sold, they have to disclose if the road is, they were going to say if it's a private road, And I said, no, let's not just say private road, let's say if it's a road that's not maintained by the public. Because then you'll notify not only the people on private roads, but the people on public easements. And that has helped some. I've gotten complaints now that say, I'm looking at this piece of land, I'm told that the road is discontinued, what does that mean? Or I'm told the road is a public easement, what does that mean? I used to get notices from people saying, help, I bought this piece of land, and now I found out, what is it? And they're like, oh, no, too late. Anyway, so I think those are the top issues as far as numbers of people. But another thing that I think is important to notice is that no item got fewer than 12 ratings of 5 at extremely important. So even the ones that most people didn't think were that important, almost a third of the people who responded think they are of prime importance to them. So I think we need to look at those issues too. And also to consider which are going to be the easier problems to solve. The constitutionality is going to be a difficult one to solve, and that's the number 1 on the list. But some of the ones that are down at the bottom of the list, one issue that stands out is fitting both the criteria of a few people having a real bad issue with it and of there being a fairly simple solution to it, is the issue of towns closing a road to winter maintenance when there's still someone living on the road year round. The law about closing a road to winter maintenance says that the town is supposed to consider population and use of the road. And they've taken population to mean, well, we don't have 10 people living on the road now. There's just this one farmhouse. And so we don't need to plow this road, and they just stop plowing the road. And the problem with that is that they will then tell the person who lives there, oh, sorry, you can't plow the road either because you cannot have private individuals maintaining a public road. There's a liability. So all of a sudden you've taken all access away from these people.
I just want to say, Roberta, on that last comment, we have an opinion, where I work,
Mhm.
have an opinion on that from, I can't remember, it was might have been the Maine Municipal Association, but I'm not 100% sure, that in that case, we don't have to, we can let them use their own equipment.
Mhm.
And so you're saying that, are you saying that there's a competing opinion that,
Mhm. There are towns that are saying you cannot maintain that road because it's a public road and we can't have private individuals maintaining the public road. I know of 2 cases currently where that's happening, where people have been told that the town is no longer going to plow to their house, but they're not allowed to plow. In one case, the person went out and on the town's recommendation, bought a plow truck, bought insurance for the plow truck, because the town told them they had to have this insurance. And after they had spent the money, the town came back and said, well, sorry, that won't do. You have to have commercial insurance. And we don't really want you plowing it anyway. So what are these people supposed to do? All of a sudden, they have no access to their home and there's no compensation for the taking. So where I say there's a simple solution to this, it's as you said, can we just say in that case, the private individual can maintain it? It's similar to saying that a private individual can maintain a public easement. It's still a public road, but the courts have said that private individuals can maintain it. There are still some questions about who is liable if somebody gets hurt.
but that issue, Roberta, is not a discontinuance or abandonment issue, because that road that you're talking about hasn't been discontinued or abandoned, it's just been closed to winter maintenance. So does that,
It's still a deprivation of access.
but is it something that this committee can recommend changes, I guess is my question, based on the charge of the committee?
That's a good question. I would say yes, but of course I'm prejudiced. I think that would be one of the things that would be fairly simple to solve, because you either say that they can maintain it or post signs on it saying, well, the Massachusetts law that we get our private way law from says that proper signs have been posted to warn the public against entering thereon. So why not say, okay, you can post a sign on the road saying, warning, this road not maintained for public use. And then let the person plow it. So that would be one possible solution. I would not go so far as to say that, if somebody moves onto a road that's already close to winter maintenance, that you then have to start plowing. They should be warned in the real estate disclosures that this road is not plowed in the winter. So that's another tweak, would be to put into real estate disclosures, but also have to let you know if the road is plowed in the winter. So there's the option of letting them plow it and posting it. And there was another thing the other thing is, I prohibit towns from facing winter maintenance if there's still somebody living on a road year round. Just say, as long as somebody lives there, if they were already there, they're already living there, you can't just suddenly stop them again in the road in the winter.
Roberta, I think in a way, I think Ryan does have a point. The closing a road to winter maintenance is not an abandoned and discontinued roads question. To bring it back to your survey request, if you were to say what are the top 5 issues that are listed on these 2 pages that think the members of your group or people you correspond with would like to see addressed by this committee, one would be constitutionality. And that's under 1, access issues. I'll just point out, neither this commission nor the state legislature wear black robes, and so we really can't be saying that something is or isn't constitutional. And the constitutionality of the statutory abandonment law was challenged, litigated, and the law was upheld in Land versus the town of New Sharon.
I want to get into that in a bit.
Okay, well,
I'll
all right.
get to it.
Okay, fine. That is something that was raised there.
Yeah.
So that's one of the, let's say, top 5 issues. What would be the other 4 top issues on these pages?
One was difficulty, determining the status of a road.
And that's under, number 3, that's at the top of your 2nd page, problems figuring out the actual legal status of a road.
Yeah.
Okay.
Can I ask a question there? Whose problem, like, the person who's buying the land or the person's already living there?
Anybody who's trying to figure it out. Sometimes it's a landowner, sometimes it's a realtor, sometimes it's the town. I get questions from various people saying, we don't know what this road is.
I just called Pete Kaufman at MDOT and he tells me.
Look on the map, look
If-
on the map viewer.
If it's maintained by the town, Pete can tell you.
Okay, well, look on the map viewer.
Hmm?
Look on the map viewer, which is
Yeah.
fairly up to date, that should
Yeah.
tell you.
The DOT map viewer, if you know how to go in onto it, if you go up to layers on the right and you click on add layers and you type in RIG and it'll come up with right of way layout. And you click on that and all the roads that were laid out as county ways will highlight in green. And then if you click on one of those roads, a code number will come up telling you what book and page number in what county that road was laid out. And if there's a D after it, that tells you it was discontinued. Those are the easy ones. The hard ones are the ones that were discontinued by the town. And it's someplace buried in the town report somewhere and nobody knows where. And sometimes, as Jim was saying, the description of the road, it will say, the road leading from the main road to Smith's Bend. Which road is it? Who knows? So you've got a discontinuance, but you don't know if it applies to the road or not. So this is where it can get difficult trying to figure out what the status of the road is, whether it's actually discontinued or not. Okay,
Sorry,
let's
I
see.
interjected. I think Jim's questions were the top 5 and I jumped in on number 2 there, so.
Number 3 would be
Defective or ambiguous action by the town or county leaving the legal status of the road uncertain. This kind of ties into number 2, it's problems figuring out the legal status of the road. So I think those two kind of go together. And prohibitive cost of litigation. One solution I see for that, or at least a partial solution. There are a couple of really good programs for low-cost mediation that are available now. Family and community mediation, FCM, will often provide free or very low-cost mediation. The Cooperative Extension's agricultural mediation program will provide free mediation if there is farmland or forest land in production involved. So that's another excellent resource. Part of the problem with mediation is that it's a voluntary process. And often by the time I hear of it and recommend to the people, go to mediation, things have gotten so blown into a feud that one party or the other will absolutely refuse to try mediation. So the question is, how can we encourage people to try that? Can we make another program available? Can we provide state funding, or can we get one of these programs, either FCM or the agricultural mediation, to extend the range of things they do so that it specifically covers abandoned and discontinued roads? Can we train mediators to specifically mediate those issues?
There is court-required mediation for civil litigation. So if you were to file a lawsuit over the status of a road, presumably the court would be requiring mediation of that through its process.
But then you have to file a lawsuit first,
Understood.
which costs money, which, as I said, a lot of these people are low income and don't have the money to spend on it.
What would be number 5 when we get beyond the cost of litigation?
Okay, number 5 would be, let's see. Lack of information or faulty disclosure of information about the road status given at the time of sale. But going back to those, the ones that were kind of at the bottom of the list that are critical for the people they do affect. One of them is feuds and violence between neighboring landowners. And I see this a lot. I've got a whole list of weapons that people have used against each other on these roads when the problem is they get so frustrated because they can't figure out the status of the road. They get different stories from different people. They go to one selectman and that one says that it's a public road, go ahead and use it. And they go to another selectman and he says, no, that was discontinued. It's somebody's private property. And you try to look up the information, and the language of the discontinuance, if you can find it, is ambiguous. And next thing, somebody's calling the police, and the police come in and they say, we're sorry, this is a civil matter, there's nothing we can do about it. And they try going to court, and maybe they get a restraining order, and maybe they don't, and maybe they get frustrated because the court won't do anything for them. And the next thing, they take matters into their own hands. And we've got, let's see, to go down the list, an iron pipe, a machete, a pistol, a medieval style battle axe, an
yeah.
assault rifle.
You said at the beginning, some of these people move to where they move to get away off the grid, kinda.
Yeah.
And yeah, I see it.
And a lot of these people, it's one thing that kind of has been a surprise to me, and it shouldn't be, because my husband is one of them. People with PTSD, they want to get out where it's quiet and peaceful. And instead they get this huge controversy. And one of the triggers for PTSD is inconsistency. And that's exactly what you have here. So it's a recipe for things blowing up. So if we can find any ways to mitigate that problem, whether it's through mediation, trying to give people resources so it doesn't get to this feud point, then that would be good. And the
Maybe
third
we should
issue,
create
which,
like a board, a mediation board like they do for other matters, like employment matters, you know, the labor relations board, a road relations board.
yeah, so far I'm it. It's getting a bit overwhelming.
That's where they don't have a number for how many cases you have of the feuds and violence.
Oh, that's one that I haven't compiled. I can go back and try to come up with a number for next. meeting.
But I think it's fair to say that property disputes generally, whether it's boundaries, roads, easements, can lead to some flaring of tempers and feuds. And it's not just roads, it's property rights in general. People could be fairly combustible about that.
Leaves falling off of a tree onto this neighbor's deck or in their pool. Serious.
I know one case that I ended up in court with someone trying to get a restraining order against somebody else. And the judge told the parties, go home, cool off, leave each other alone. These property issues can get very heated. Don't let this erupt. And a week later, it erupted.
It can happen. So Roberta, those are the top 5 issues that you've seen raised by people who contact you. Was there something, were there other materials you wanted to present this afternoon?
Yeah, just
Sure.
one more point that I want to make here. The third one that's kind of, that looks low on the list, but is, really important, is roads that were discontinued with no easement retained, leaving properties legally landlocked. And, there are a lot of those, the question is there some way that we can restore access to these people? But how do you do it without trampling over the land of somebody else that's considered their private property for years?
Which one was that one? I can remember.
My concern, Roberta, and I guess to the commission here.
I'm deaf in one ear, so everything sounds like it's coming from this side, so if I look the wrong way,
Oh.
that's why.
My concern,
Mhm.
and really this is for the whole commission here,
Mhm.
is anything we do end up proposing,
Mhm.
how do we deal with things that have already happened in the past?
Hmm,
You know, I mean,
ex post facto law.
there's preemption, there's municipal home rule, I mean, there's so many things going through my head right now about the law gets changed in 2022 or 2023 now. Okay, let's just assume. And it's to deal with one of the issues you just raised, a road was discontinued in 1997 and people have like. Is it gonna change anything for the people that are there now?
That's one of the big problems. And people have asked me various times when we've gotten changes in law made, they've asked me, is this going to help you? And I've said, no, it's not going to help me, but I'm more interested in helping the next guy down the road. There are some things that I think can help people that already have these problems. So, definitely that's going to be something we're going to want to look at.
I think Steve has a question, and I apologize, we haven't gotten to you.
Hey, yeah, not a problem. I haven't been able to interject because I've been locked out of commenting here. But I was wondering if there was, like in Frenchville here, I know there was one instance where the town historically plowed a short private way. And then when the legislation came out where there was a risk of liability, they stopped. That created like a feud in the town of Frenchville. I'm wondering if there's any instances where private ways are turned into town roads to allow the continued, in this case, practice of snow removal and avoid the problem of liability. That's my question. Thank you.
That's where you get into Title 23, Section 3105A, which allows towns to use town equipment on private ways when it's in the best interest of the public for fire and police protection. And the question is, what's the definition of a private way? Is it a private road or is it a public easement? And what they've decided is that you cannot use that law to plow private roads, but you can use it to plow public easements. And what some towns have done is where there are some towns that for years and years and years have been plowing private roads as a courtesy to their taxpayers and older citizens, whatever. And all of a sudden they're told that, well, no, you can't do that because you can't use public funds on a private road. And what some towns have done is gotten these roads dedicated as public easements, which means that now they're not private roads anymore as such, because now the public has to be allowed in, but summer maintenance is still done by the private landowners or road association or whatever, but it does allow winter plowing, but it's not mandated. So in some towns, somebody would say, well, we'll dedicate our road to you for a public easement, and the town will say, no, thank you. And then they're still stuck.
And the concern too is that people might say, yeah, it's open for public travel, and then they'll put up. Once the work is done by the town, they'll put up signs saying no trespass, private road or whatever, and they try to have it both ways.
Yeah.
You can have problems on either side.
Okay, anyway, I have another handout here that I call small tweaks. And these are ideas that my husband and I have had, or other people we've been in touch with have had, for things that might be done to try to mitigate some of these problems. Some of these aren't really small tweaks, some of them are. Some of them would require a bunch of work to actually make them work, but they're at least ideas to start with. If any of you are familiar with the process, if any of you are familiar with the process of brainstorming, what you do is you throw out every idea, no matter how wacky it is. And maybe a wacky idea will trigger somebody else to come up with an idea that actually makes sense. So that's what these are. These are ideas for things that might be done to mitigate some of these problems. I'm not gonna go all the way down through that right now. You can take it home and look at and see if there are any that you think are good ideas or trigger some other idea. But the other thing I really wanted to get into, because you asked, was about Jordan versus Canton and the constitutionality issue. Jordan versus Canton was a case over the limited user highway law. That law went into effect in, I believe, 1967. And by 1970, it had already made its way all the way to the Maine Supreme Court. And what it said was basically that the selectmen of the town could just decide that they didn't want to maintain a road anymore because it wasn't of sufficient use and value to the traveling public, and they just declared a limited user highway and stopped maintaining it. And it didn't take the court long to say that you can't do that, because when you stop maintaining a road, they said that a public road with no public maintenance will inevitably be destroyed. And the destruction of property access, that access is a property right attached to the property, and you cannot destroy or even damage property access without going through both due process and just compensation. Now, some of the interesting things that happened in there was that they said that it doesn't matter what the legal status of the road is. What matters is the actual and factual consequences of what they have done to the road. So if I can find it here someplace, I have some quotations from Jordan versus Canton. I have too many things in front of me here to keep straight what I'm doing. And I apologize for not being more organized. Okay, here we go. Okay, they said that it's well established that the owner of land abutting upon a conventional highway has an easement of ingress and egress. This has been treated as a property right attached to the land. The courts unanimously hold that such an owner is entitled to just compensation if this easement or property right is taken or damaged. And then it goes on, we hold, however, that when all reasonable access has been destroyed, a property right has been taken within the meaning of Article 1, Section 21, which says that you can't take private property without just compensation. The defendant contends in the instant case that since the road has not been technically discontinued and remains a public way, the plaintiffs have not lost their right of access. Now, does this begin to sound like a public easement? But cases involving loss of access depend on the practical and factual consequences of governmental action rather than the legal status of the highway. In short, it's the actual and practical discontinuance rather than technical discontinuance that destroys the easement. The fact that a limited user highway continues to have a legal status as a public way over which there continues to be a public easement of travel is meaningless if there is no longer any public responsibility for maintenance and repair. Without maintenance or repair, it is only a question of time before a public road will become impassable or unsafe for travel. The rigors of Maine weather, the action of frost, and the erosion from rain and melting snow will speed the process of disintegration. The ability to use the road for vehicular travel, and thus the abutter's easement of access to and over the road to the public road system, will inevitably be destroyed. And then it goes on, in judging whether a statute satisfies constitutional requirements, we look to the possible and not merely the probable consequences which may flow therefrom. It is not what has been done or ordinarily would be done under a statute, but what might be done under it that determines whether it infringes upon the constitutional right of the citizen. The Constitution guards against the chances of infringement. It is evident that under the statute, the citizen might in some cases be practically deprived of all remedy. And this is what we've seen over and over again on public easements, is that they're told, well, no, you haven't lost access, you've still got a public easement there. But let's see, we take Reg Farley, who graded his road in the fall just before it froze, had it all nice and smooth and level, looked beautiful. And by the time he came back in the spring, after he figured that the road would be firmed up enough to get into his land, somebody else had driven in first and left 2 ruts straight down the middle of it. We have the Ed Rose Road going from Fayette into Wayne. Somebody drove down through it during hunting season a few years ago and left 2 ruts all the way down to the beaver dam where they found they couldn't go any further, and they backed out the same 2 ruts. And now every time it rains, the water washes down those 2 ruts and washes it out. And the water comes to the bottom of the hill, spills over the brook and goes down into the Cassett Lake. We have our road where in the first 15 or 20 years that I lived here, after my husband had already been there for 10 years, about every 2 years, we had another logging company come in and they just use the road and then leave. They didn't have much regard for what they left behind. And so every 2 years, we end up rebuilding the road. So how do you compensate for the taking of access? If you cannot get to your property because the public use of that road has ruined it, there's another taking every time it gets destroyed. And this is something that the court didn't consider in Jordan versus Canton is, actually, they did kind of consider it in Jordan versus Canton, but they weren't thinking of public easements. There's another case of Lamb versus the town of New Sharon, and his case was in an abandonment. And what the court said was that because the public has not complained about the condition of the road for the last 30 years while the town wasn't maintaining it, that the public has now lost its right to complain. The public has lost all its rights in the road, and therefore there is no constitutional taking here. You don't have to consider due process or just compensation because there's no taking. The road was already gone years ago. But the problem with that is that as soon as you make it a public easement and make it known that it's a public easement, then, as I said, build a better public easement and the world will beat the pathway to your door. So you declare the road abandoned, you declare that it is then a public easement. The landowner says, well, I've got a public easement, I guess I can get to my land. He goes in, he builds up the road so he can get to his land, and the public comes in and tears it up. And he rebuilds it again, and the public comes in and tears it up, and he rebuilds it again, and the public comes in and tears it up. Every one of those is a taking. You cannot make one-time just compensation for this taking that goes on and on and on and is repeated. I've got another whole list of cases where somebody has written to me and said, I put $10,000 into this road and somebody has just ruined it. I put, $5,000 into the road this year and somebody's ruined it. I put so much into the road and somebody just moved in beyond me and came in with their concrete trucks and ruined the road again. Yes, I think we have a question.
Steve.
One second.
Okay, there we go.
Sorry, Steve, I don't know what the delay is on making that button work, but I think you're good now. Thank
There's a
you.
lag issue.
Oh, can you hear me now, though?
Yes, thank you.
Yeah, so, I was just wondering about like the environmental liability. I believe you had mentioned at a previous meeting that when, somebody like another user, whether it's industrial or private user, uses that road and they might be introducing siltation to a stream, for example, there might be liabilities associated with that. So that's another issue that I just figured I'd mention while you're talking about it. Thank you.
Yes, yeah, in that case that I said in Wayne, it's a steep hill and those 2 ruts go right down and the water washes right down into the stream and down into the Cassett. The Bowling Hill Road in Liberty is another example. The runoff from that goes right straight down into Lake St. George. And I've got pictures someone took with a drone looking down on the lake. And you can see this plume of silt going out into the lake. They sent somebody out to look at it and they said, oh, no, there's no problem there. We don't see any silt. Well, that's because they looked at a time when there wasn't. If you'd looked right after a heavy rainstorm or right after somebody had driven through, they would have seen that there is definitely silt going down in there. stream crossings, fish passage. You know, there are all kinds of issues with these. And one of the things that I find kind of interesting is if you look at the names of roads on my list of discontinued roads, a common term that comes up in the names of these roads is hill. Boland Hill Road, Oak Hill Road, Surrey Hill Road. And the next most common term is swamp or bog. Spruce Swamp Road, Bog Road, there's a Bog Road in Mount Vernon, there's a Bog Road in Fayette.
One in Caribou,
Excuse me?
one in Caribou.
Yeah, they're all over the place. And the reason these roads were discontinued was because they were difficult to maintain. So what do? You stop maintaining them, tell the public to keep on using them. And what's gonna be the inevitable result? You're going to get stream runoff, you're gonna get erosion.
You know, I mean, I'll take this, I appreciate when you put it together here, and I'm gonna, you know, review it on my own time, but one of the things that, strikes me out, you know, comes to me, I guess, when I'm reading or looking at some of this is when a road is laid out or created, either the state or even I think local, like Jim said, through subdivision, approval, it has to get recorded at the registry of deeds. But when a road is discontinued, from what you're putting here, that record, if there is one, is left at the town office level, right?
There is a law now that says that when a road is discontinued, it's supposed to be filed both with the registry of deeds and with the DOT. It's
Okay.
under, Title 23, Section 3026A. Also under the new abandonment law, and shortly before the new abandonment law went into effect, the old abandonment law, Section 3028, they had added in, required, well, not requiring, filing it, they said that it should be filed with the registry of deeds. But the same law also said that lack of filing in the registry of deeds didn't prove that the road wasn't abandoned.
Okay, but just let me ask you this, then if it's there, you're indicating here that reports should be, annual reports and warrants should be submitted to the state library?
Mhm.
Are you suggesting then moving forward to do that or going back in time?
The library has a pretty comprehensive collection of town reports because towns are supposed to have been filing them with the library all along. But there's a couple of problems with that. One is that not all towns did, or there are gaps in it. I took about, I think, 24 of our town reports down to the library because I found they had a bunch missing that I had copies of. And a lot of the recent ones, it seems like towns are forgetting that that's something that they're supposed to do. But part of the problem with that is that they file the town report. Not all town reports have the warrant in them. Most do, but there's some towns that don't. There are very few towns that give the results, the votes on the warrant in the annual report, and that's wonderful when I can find it.
What, think about that for a second, the annual report is published before the town meeting occurs, so the results wouldn't be included in the annual
If
report.
they could put it in the next year's. annual
Okay.
report.
Okay, well, that would require a law change all by itself, I think. I don't think there's any requirement in the law to do that, so. But that's helpful, so I guess what I'm trying to get at, Roberta, is your recommendation there is moving forward. You're not expecting towns to try to go and recreate and do that back in time.
No, it would be nice if where there are gaps in the library's record, if they could fill in the gaps. But going forward, at least, if they could file.
Yeah, I mean, I think from my experience, if they're not there, it's gonna be really hard to fill those gaps in some places because there might not be a town report that exists from that year or that is, you know, it just.
You might be surprised how many towns have said, we don't have those records, there was a fire and then on.
Fire, yeah, yeah,
And that's the very reason that they're supposed to be filing them with the library.
right,
And sometimes we can find them in the library and sometimes we can't.
And as far as certificates of discontinuance being recorded in the registry, I think that obligation goes back to about 1959, so
Yeah.
some of the older ones wouldn't be there.
Yeah, and yet finding those is rare. Once in a while you can find it if you search the name of the town as the grantor. Or with miscellaneous. Sometimes you can find them, but lots of times towns apparently weren't aware that they were supposed to be filing them. In fact, when they got that change put into 3026 a few years back, Tom Doak came to me, and you're from Maine Woodlands, and he said, "Did you know they already had a law that said this?" And I said, "Oh, you mean Title 23, Section 3024?" And he said, "Yeah, I kind of figured you'd know." They did have that on the books that they were supposed to be filing since 1959. If they discontinued a road, they're supposed to be filing it in the Registry of Deeds, but lots of towns didn't. And this is one of the places where ambiguity comes up, because somebody can say, okay, the town has on record that they discontinued this road in 1961. Where's the certificate of discontinuance in the Registry of Deeds? And it's not there. And what the law said was that the language of the law is really ambiguous. And I can't quote it exactly right now, but it's something to the effect that the discontinuance is invalid against the person who didn't have actual notice unless it was filed in the Registry of Deeds. Well, if you think about the language, what that means is that you've got a discontinued road, you notified 9 out of 10 people on the road and you forgot one. So the discontinuance isn't valid against that one, but it's valid against everybody else. It doesn't work. But what they intended was that if it wasn't registered someplace, that it wasn't valid. So now people say, well, okay, it's not filed, so the discontinuance is invalid. Now we're at it.
Yes, hi. I've got a question about locally here in Hamlin, for example, the State Department of Conservation did a harvest on public land on a conservation area, and they established these roads for the harvest. They're not planning on coming back for 20 years. They told people that it would be available for access to the public. I'm just wondering if there's anything special about those state-owned properties and what they said as far as available access, if you know anything special about that. Thank you.
I don't really know about that. Are these wood company roads? Oh, you're muted again.
Well, there were harvest roads established by the state to conduct a harvest in the Bureau of Public Land Conservation Area in Hamlin. They did.
State agency creating roads on state land, in other words, just for the.
Right. Yeah. And they told people that expressed interest in what they were doing for management that the roads would be available for public access. So I'm just wondering on that instance, for example, or what the rights or whatever. I assume that the state is not going to be plowing those roads or maintaining those roads. Is the public allowed to do that then, or just use them? That's, I guess, the question I have.
We have anyone here who has contacts at BPL? It's beyond our jurisdiction, but we can answer the question.
Yeah, so the short version is they're building roads to cut wood. And if they either treat them as a winter road and they close them up when they're done, or they treat them as a public access, public use road, and they leave them open so the public can use them for, hunting, fishing, ATV and snowmobile and whatever. They're entirely within the public unit, so it's not like it's access to another landowner or anything. And then roads basically get categorized. They're either, winter roads that they close out, put rock barricades across or whatever at the end, or they're gravel roads, much like they're in any of the public units that are then open for the public to use with motor vehicles, ATVs, snowmobiles, whatever.
Thank you.
So
That's something I haven't gotten into much.
Right. Yeah, they're not, the only time they would fall into some other level is if it was a road that multiple landowners are using, which there are situations out there. Typically what happens is, we may get it right away across 7 islands for hauling, or Prentice and Carlisle or whoever and vice versa, and they'll do, you know, at that point in time, they either got some kind of agreement over road maintenance or a trucking fee.
And how, like where I'm from, right, we have the North Main Woods. Do you have that down in this part of the state as well, like where you have a group of landowners that kind of control access to all that area?
No, I mean, the North Main Woods is pretty unique, and so, you know, in the southern part of the state, you may have individual landowners who share a road and maybe barricade it and share gates or whatever, but there's no organized that I'm aware of anyway, like North Main Woods.
Okay.
They talked about doing that down east and the landowners rejected the idea for whatever reason. There's a cost to it. Nothing's free. On that note, if you don't mind, I've got a question on your, I don't know which it is, page 2, I guess, or page 3 of what you handed out on the, your last 2 sentences, it says, to educate inland fisheries in towns that public easements are limited to foot or motor vehicle and exclude ATVs and snowmobiles. Are you saying that's what public easements now do?
If you look at Title 23, Section 3022, it defines a public easement as being for use by foot or motor vehicle. And it refers to a specific definition of motor vehicle. And if you go to that definition, it defines a motor vehicle as excluding ATVs and snowmobiles and electric wheelchairs.
So that's what came under the law that was changed just a few years ago, correct? Because I think that's new, it wasn't always that way, or is that,
For quite some time, I believe.
because electric wheelchairs didn't exist
Hmm.
till recently anyway.
Yeah,
but-
that's true, so it doesn't go back terribly far. But,
So does that apply to all existing public easements?
that's one of the ambiguities. I would say that that is the definition of a public easement. Section 3021 and section 3022 are the definitions of a public easement.
Is a road though that is discontinued and the easement retained the same as the legal public easement that Jim mentioned at the very beginning of our meeting as one of the 3 types of roads in Maine?
I would say yes, because if it isn't, then we've got 2 different types of road with the same name.
Well, I think.
And I know we do have that in
We have
places.
private
but-
ways, and
Yeah.
we may have that with public easements as well, because those public easements under 3022 may not be entirely the same as the ones under 3021. And so 3022 talks more about those private ways that were formerly private ways that became public easements, as opposed to what the leftovers after discontinuance or abandonment of a public way. All right. Well, I think that lists a number of issues and thoughts. Circling us back to where we go next, Roberta, if that's okay?
Yeah.
Okay.
I could go on for another hour, but I know you don't want that.
Well, no, I don't want to cut anyone off prematurely, but there are other things we need to discuss, big picture, to get us to what we had to do. Our duties, I'll circle back to this part because I wanted. What we've discussed has to be brought back to what we've been asked to do. We're supposed to consider 4 things: property owner liability, including personal injury, property damage, and environmental damage liability resulting from public use of an abandoned or discontinued road. Public easement retention over an abandoned or discontinued road, including the scope of the permitted and actual public use of that public easement. Statutory terminology related to abandoned or discontinued roads. And the statutory process for the abandonment or discontinuance of a road, including barriers to determining the legal status of a road. For matters other than those 4, we are to look at a list of 6 and prioritize for consideration by the commission by determining which matters have significant negative impact, qualitatively or quantitatively, on owners of property that abut an abandoned or discontinued road, owners of property accessible only by traveling over an abandoned or discontinued road, recreational users of an abandoned or discontinued road, members of the public, municipal, county, or state governments, and physical integrity of abandoned or discontinued road and surrounding land. We're to look at those, consider those, prioritize those matters, and then develop recommendations on ways to address these matters, including perhaps recommendations for statutory changes. So some of these tweaks we might consider if based on where they are on our priority list. So I think that the next step would be to have this public hearing that we've got coming up to get public input on these areas that we've been charged at looking at, the areas we shall look at, and the areas we're supposed to prioritize. And only then can we start thinking about, you know, ideas that Roberta might have and others might have as to how to address these concerns. Does that make sense? It's our statutory charge. I think that any notice that we have of this public hearing ought to make that clear. This is what we're supposed to be addressing. This is what we're looking for information on. This is what we need to do and how we act, you know, so give us your ideas, give us your concerns, your priorities, and then your ideas for addressing these concerns.
So we better have a long day plan for this.
Yeah,
Is this for our next scheduled meeting?
yes, that's what we tentatively scheduled. So concerns, priorities, and ideas to address those concerns. I know there are probably a lot of people with a lot of things to say on these topics.
Well, I think we have to establish a limit on the amount of time a person can speak.
Yeah.
But we should not, limit the amount of information they can provide. So obviously, if they want to put all of this in writing, come hit some of the highlights in verbal communication if they wish.
Right.
But everything they want to submit it in writing ahead of time or at the
I
meeting.
was gonna suggest.
I think we need a 3-minute time.
That's-
Like we do in legislature.
That's what the legislature does, and that's what a lot of planning boards and boards of appeals and the councils have been doing lately, because otherwise you'd be there all day. Yeah. So that's right, 3-minute limit on what you say, and I'll need a 3-minute egg timer or something. 3-minute limit. Yeah, I'll figure it out. So we'll do the 3-minute limit, but as Ryan mentioned, people can submit written materials for our consideration as well. I have no idea how many people are going to want to speak.
Depends on whether or not we actually put out when they can speak, right?
It's true. This is true. The amount of notice will determine what we get for feedback.
Well, yeah, you're gonna have folks that are affected by this, people that you deal with,
Right.
but you're also gonna have people that Rebecca works with, the municipal folks.
I would hope that they would know about this and
They're gonna have a very different opinion in some of these issues.
Right. And some of the conservation agencies may have concerns about this too. And some of the woodlot owners,
Probably everybody on this
fishers,
commission is gonna have people with opinions that they want to express.
right? Which is why I want to try to get this agenda in the notice of this hearing out sooner rather than later, so that people can post it on their websites, can get it out to their memberships, so that when we have this hearing, we're getting people who are prepared and have something to tell us.
Is this still just an afternoon meeting or is this an all-day? meeting?
Right now it's scheduled for the same 1 to 4. We want to see if people are available longer. Do we want to do that? Everyone look at their calendar right now, or?
Just wondering, I mean, depending on how many people you get,
We could start it earlier.
I don't know how many people are gonna be want to testify, and again, depends, I guess. Not remaining way to know ahead of time.
Is the whole meeting though dedicated to just hearing comments?
Well, we could start evaluating what we do with those comments, if there's enough time. Yeah. That was the thought, because we have to prepare a draft report and then a final report, so don't have that many meetings. So,
I can find out the logistics for starters of whether this room is available earlier. Do people want a doodle poll from me or an email reminder, or do you want to take a moment now to see if people can make themselves available for more hours than just one.
It's what date?
Say the 14th, I'm looking to double check, yeah.
That's a Wednesday, right?
When people want to submit written testimony, how should they do that?
I think we can share the email box that I created and then it will come to me. I will share that with you all in an email, because I want to make sure I get it right.
I think Steve has a comment.
Thank you, Ryan.
Yeah, thank you. The biggest thing that came up to me as far as a concern that that would be applicable to a lot of people up here is what came out today, that if it's a town road, it's decommissioned, it's an easement, but that easement excludes ATVs and snow sleds access, right?
We need to look at that.
And that
Because
contradicts.
that is, to me, that is the big one. And because in northern Maine, and Ryan can chime in on this, but I would say the biggest interest in any decommissioned roads would be for that ATV and snow sled access. That's my biggest thought there. Thank you.
Title 12 says you can use. So if that's true, we've got conflict with it.
So ATV law prohibits you from using property unless you have landowner permission anyway,
But it does also, in the same ATV law, say you can use these easements.
an easement. And then
So,
snowmobile law is also, it's not what we would consider reverse posting, where you can ride a snowmobile anywhere in the state as long as it's not posted or you've been told on.
yeah, you don't need landowner permission. But you do need landowner permission to operate an ATV. However, the law says on a discontinued
Yeah,
road,
one
or
of the-
road closed for maintenance, you can operate an ATV.
And we get a lot with camp owners that ask, they say, well, I wanna be able to use my ATV on this road, it's a seasonal road or an easement to go to their camp during times when they can't get there by truck. And I see like, it says prohibit ATVs on public easements unless unanimous landowner permission, which I can see that being pretty slow. Because not everyone agrees with everybody, as we've seen with the battle axes and everything that goes on. So you kind of put the landowners at odds with each other with that.
And
And I said, this is a starting point. This is-
Right.
this is throwing
Title
ideas
12.
in.
Title 12, you have the section number?
I don't have it right handy, we'll put 13-157, which I think that's, I don't think that's,
I don't have it in front of me, but we can certainly get it.
Yeah, I'd like, because I think a lot of this comes down to the misunderstanding of which easement we're talking about, and you know, the ones that were retained easements when they are discontinued versus the ones that are, or like if I give you an easement, let's say that you cross my property, that's a totally different easement than what we're
That's a
talking
private
about.
easement.
Yeah,
right, and snowmobile and ATV statute, it's very distinct, where you can't ride an ATV unless it's a designated ATV trail or you have landowner permission.
Yeah.
So these people that are just riding on these roads, most likely are in violation of Title 12. Anyway,
See, this is
Well, they're
where,
doing it under the guise of
right,
they go to the town and the town says public easement in Title 12 elsewhere says you can use them at a discontinued town road.
Yeah.
They say you got permission to use them, which is the dispute, because now everybody's using it.
even if
But
they're not
nobody's
designated as an
maintaining.
ATV access route like they do on the townway.
So access routes are strictly on public roads maintained for regular vehicle traffic by the towns or the counties or the state.
Yeah.
So they're completely different. You can't make a quote unquote ATV access route on a discontinued town road. It's in a whole different category of law.
Yes.
But they make ATV and snowmobile trails on them based on the law and then town's guidance. That's why we continually tell them through the programs, go get landowner permission and work this out with the landowner. Because in most cases, what the landowners are complaining about is abuse of the road and no maintenance. So, you know, I tell them, I said, go help with the maintenance.
Mhm.
You know, if it's costing a landowner $3,000 a year to do this, then let's help them with that cost. Because it's just the right way to treat your neighbor, you know, that's my outlook.
And what I've seen is that the snowmobile clubs generally do a very good job, or the ATV clubs, generally do a very good job of maintaining trails, trying to keep good landowner relations. And all it takes is one road who goes out there in the middle of the
Oh,
season and does donuts.
Yeah.
And just tears things
And
up.
we've seen, you know, like you mentioned in here at one point, the law allows us to close trails, it's enforceable on ATVs during mud season. But we're seeing more and more of we close it during mud season and mud season comes late, like 3 years ago this happened, so everybody went in with Jeeps and pickups, cause they're like, screw you, Brian, we're going fishing. And then they destroyed the trail,
Mhm.
which we weren't allowing ATVs to use, now we had to go back and repair in order for ATVs to even use it and the landowners to use it. Which is why you're seeing more and more of the lovely yellow gates going up by landowners all over the state.
Yeah.
Because there's no mud season law that applies to regular motor vehicles. So the only other option is gate them out.
We can slide in a law here that mandates membership in clubs. Let's get real controversial.
That'll guarantee.
you to be the speaker that brings that up.
The reality is though, you'll kill everything else, nothing will happen.
Yeah, I know.
They doom it.
Another issue that we run into with the ATVs is that the ATVs laws say that you cannot operate a motor vehicle on an ATV trail.
Same as snowmobile law.
So, right, so when you have a public.
But it says
easement-
that unless you have landowner permission. The law says you can't operate an ATV on a snowmobile trail. You can't operate a truck on a snowmobile trail. You can't operate a truck on an ATV trail unless you have landowner permission.
Okay, so what if you are the landowner?
Then you got
Drive
landowner
drive
permission.
the truck on it, drive it.
Mhm. Okay,
But the question mark that always comes up is, we own in the middle of the road, I own this side, she owns the other side, and so now, do I have the authority to use it? Or do I only have authority to try to ride on two wheels across it, right?
But
That's
Brian,
the issue.
did you just say that if you can drive a motor vehicle on an ATV trail as long as you have landowner permission?
Yes. Ultimately, it all goes back to the landlord.
So if I went and got the landowner's permission, you're talking multiple landowners, right? You got all the landowners' permission to say, I got this little vehicle that I can't register as an ATV, but it fits nicely on the trails. And get all these people to sign, would I just keep that on me? And if a warden stops me, I just show them that and I'm good to go.
Well, they would come down, and then you're coming down to motor vehicle law, so you have to look at like whether, because you're operating an unregistered motor vehicle at that point, you have no registration at all.
No, I'm saying if you registered your.
Oh, you had a
vehicle,
registered
a registered vehicle and you're on an ATV trail.
Yeah, as long as you have permission from every single landowner on there, it's an easement. It's, you can access it by motor vehicle.
Cause again, a lot of our quote unquote ATV trails, snowmobile trails are actually on paper company roads.
Yeah.
You know,
It's not. like-
and they're open to motor vehicles most of the time, so the law that says you can't operate them on, you know. That would be in conflict, so that's why, you know, if it's allowed, if you have the landowner permission, then you're good to go. Just like. You know, I've got landowner permission to use my ATV in places that's not open to the public at large. Same idea, right? I mean, it's, if the landowner is willing to let you go, then you can go.
You know, where I ran into this was where somebody bought a cabin out in the middle of the woods. The real estate disclosure said that it was seasonal and gave access to ATV trails and snowmobile trails. And that the road was a private road that was maintained in cooperation by the abutters. It turns out it's not a private road, it's public easement. And it has been designated as an ATV and snowmobile trail, the road itself.
Right.
And it sounded from the real estate ad as if it gave access to the trails,
Which it does.
but it didn't say that the road that gives him access to his property is an ATV and snowmobile trail. So he tried to drive to his cabin and got royally reamed out by the ATV owners because he was driving a motor vehicle on their trail.
Well, it was close, right, because they know normally that now their damage is gonna be there and they're gonna have to pay to fix it because it was closed during mud season, and they were out there with a regular vehicle. And that's,
This wasn't
you
very
know,
mud season, no.
no, alright, well, that's the
They
issue.
were just chewing him up.
Right,
being
now,
on the
if you
trail.
have landowner permission, same as anything else, I mean, we had the issue in South China a few years ago where we had 5 landowners, you know, and we had a trail that went across and 2 of them were ATVers and 3 of them were snowmobilers, and they get into this, you know what, contest.
Hmm.
And one said, well, I'm not gonna let you go if you don't let me go, and the whole trail got closed, right? And then we finally said, well, that works really good, guys, you know, I mean, you either work together or nobody wins, it's either we all win or we all lose. So that's the unfortunate reality, but the bottom line, we've always, the ATV task force in 2019, it was all about, ultimately, the final say is the landowner. Problem in this case on these roads is, like, you know, is the right of way a landowner, or are all the landowners that make the decision, and what does that right of way come into play on it? And I think that's the issue that needs to be cleaned up. I mean, we changed ATV law in 2004 to say you've got to have landowner permission to operate. But it still gives the exceptions in some areas.
What it comes down to too is like, we've talked about a lot with reverse posting on land in general. And the only thing that we have in the state that has reverse posting is ATVs. For recreational vehicles, so you have to have landowner permission.
Unless you're on a designated trail, which we designate because we've got. Yeah. That's why I require all the clubs to, you know, on the ATV side, we're chasing the clubs and 3,500 landowner permissions. And the Joe does not want that on snowmobile side, because they're probably looking at 10,000 landowner permissions, and it's a lot of work to track it all. But the other side of the coin is the landowners deserve the right to decide what is used on their land. You know, my belief is, you know, we've got a really neat system in the state that's been traditional, but unfortunately,
then we've
2
got a
or
lot
3
of
people
out-of-staters moving
abuse
in.
that, and that screws everybody else.
When we have people from out of state moving in who don't realize that that's the main tradition, and they think this is my property and I'm guarding it, nobody else can come on it. And that's where you get a lot of these.
Well, we've got the opposite going on right now in Rumford. We got a guy up there who bought land in on this road 3-4 miles. And bought an old camp, and he wants to make it a home, right? We're still the bug out state, obviously.
Mhm.
But what he's figured out is in order for foundation and everything else, he needs to get, you know,
I know.
bigger
which road you're
trucks in,
talking
right?
about.
And the reality is the road, there's a bridge in question on that road, which I think Boise actually put in last, because they're on there too. And so if they get ready to go cut, they're gonna upgrade that bridge and they'll haul wood out. But they're not, so they don't wanna spend the money. It's a snowmobile and ATV trail, which we've got a bridge there capable of snowmobile and ATV. He wants us basically to build him a full-on road bridge, 100,000-pound capacity, and upgrade the road so that he can do his house, or he's gonna try to block us all off. And we talked about sharing the cost, but even at that rate, you know, we were looking at about $12,000 for the snowmobile program, $12,000 for the ATV program, and 4 or 5 other landowners at $12,000 a shot. And all those other landowners said, we're not interested because we got no need for it. You bought the land, you're trying to build your house, you don't want to build your house, fine, but if you want to build your house, you pay the bill to get in. And so then he came back to me and wanted me to use ATV money to make up for all the other 4, and I said, that's not a reasonable use of public money. And he said, then I'm gonna figure out a way to get trail costs. And so what do I do? That's the struggle I deal with, and we hear it every week.
I think part of the issue there was that the bridge was built in such a way that you cannot get a wide vehicle over it. It's got concrete or granite or something.
Right, it's
But
not,
this
it
is
wasn't
outside.
built, when the paper company, they put these temporary bridges on.
Well, this is a new bridge. that
They
was-
pulled it out, and when they pulled it out, we built an ATV snowmobile bridge. And, you know, we're dealing with maximum width of 65 inches on ATVs, right? So we didn't build this great big wide bridge, that it's not, I mean, the abutments aren't strong enough, the steel is not strong enough, and the width is not enough for what he wants. And I offered to share it, but again, I said, you know, everybody needs to step up. Well, all the other abutting landowners said no, and really, you know, I empathize with him because they're all Maynards, and they're like, who's this freaking out of state or trying to tell us all to pay his way? And that's how this is going.
And the other issue there is that, the real estate ad said
Oh, I'm
that the
sure.
maintenance was shared by the abutters.
Yeah,
And the abutters are the logging company, and a scout camp that hasn't been to their land apparently in years,
right,
and town land,
right.
and him.
Yeah.
So who's gonna share? Nobody.
Well, I mean, they all could,
They
and
could, but they're not
arguably
gonna
maybe
do it.
all should if they can, you know, whether they can. or not. But that's the big thing on our part. I mean, Joe and I routinely try to cost share stuff, but we say to people, you know, share is the key word here. I got a bill just from Fort Kent, want me to pay $37,000 to repair a culvert replacement. And they want the ATV program to eat the whole bill, and I'm like, that's not gonna happen. And so all the towns get in on this, the snowmobile program get in on this, and the ATV program get in on this, and I'm willing to pay my fair share, but I'm not gonna pay up the whole bill. But nobody else wants to put any money into it, so we're back to, what do we do?
Mhm.
And legally, there's nothing says they have to. And that's the struggle. I keep encouraging people, if we all play together and we all do our part, then, you know, it makes it work, but generally speaking, most of these paper companies aren't interested in spending money on a bridge until they're actually cutting wood. Cause they build that into that,
And this is where I get frustrated with the real estate disclosure.
right, it
Because
should have
if-
said that.
If it had been accurate, he might not have bought that property,
Right.
or if he had, he might have bought it knowing what he was getting into.
They're a salesman.
And I understand, they have the right to want to sell their land, but if you can get a good match between the person who's buying it and what they're getting, you know, there are people who would love to have a spot like that.
Right, no, I don't disagree, and I mean, it was a camp, the previous owner, it was fine for what they did, right? And it's really fine even now for this guy if the house was built, but it's not built, and it's not fine to get the materials in there to build it, and I get that. And, that's the big struggle, but as we've all heard these stories of, particularly during COVID, of people buying houses without inspections and everything else, and unfortunately, you know, we make those kind of mistakes, we own some of that.
And here's another brainstorming idea, instead of coming in with a concrete truck, you come in with a wheelbarrow.
Well, yeah, that's probably unrealistic.
Well, I say that because, when my daughter and her husband built their house, they had an excavator come in and dig great big holes so they could put in footings under it, because they wanted to have not just a slab, but 4-foot walls under the slab to support it, because they were building their house out of rammed earth and tires. And it was gonna be a heavy house. And they dug the hole and found out that there was a spring that fit into the hole. So they ended up, as an alternative, filling the entire hole with rocks. It took my daughter most of the summer with a wheelbarrow, but she did it. So
Well, I can
if
tell
you're
you, the majority
determined
of
enough,
people are gonna
things
do
like
that.
this can't be done.
Well, why don't you, but for a change, you tell this guy that. Because I've talked to him several times this summer.
You can load him the wheelbarrow.
Well, I do a lot of what I call talking people out of trees. I try to get them to say, hey, you gotta see the other side too, so.
But I think part of what this discussion shows is that when we're looking at that list under B of duties, recreational users, the impact of abandoned and discontinued roads on recreational use is something. It's of importance to ATVers, to snowmobilers. We need to prioritize that as opposed to some of the others, so that this conversation is useful, and getting these comments will be useful in knowing what we're going to be addressing. So the idea being on the 14th, we convene. We have a public hearing. You know, or get as much public comment as we can on these issues, 3 minutes apiece. If people want to supplement that with writing, great, we'll look at the written materials. With the, assuming we have some time after getting public comment, we can start talking about prioritizing issues, which ones we're going to look at, and maybe start brainstorming some solutions or set up some subcommittees to start looking at some of these issues so that we can get all of this going on parallel tracks. Of those of us who were here today, who has a calendar to see if we can meet a little earlier on the 14th?
I have nothing that's going
Okay, if we were to start at, assuming the room is available,
I've already emailed, we'll find out.
I understand, thank you.
Yeah, sure.
How early would we want to start? Would we start at 10 o'clock?
10 would be fine. Any earlier than that, I'm leaving in the dark, so. probably-
Yeah, we
In the
don't,
dark anyway.
I'm leaving in the dark.
Right.
so.
10 is fine.
From
My house, I live in St. Agatha, so my house is 4.5 hours.
Yeah, we will not start any earlier than 10 a.m.
Still dark.
Are you coming down?
I will come down for that, yeah. I was down this time because I moved tomorrow. It worked out great, but I will come down for that. Probably, yeah.
Weather permitting, no, it's not.
Well, yeah, of course.
Oh, good heavens.
Room permitting, let's plan on starting at 10 a.m. then.
So are we breaking or are we going right straight through?
Oh, no, we're breaking.
Well, I'm just asking.
I
Clock,
break at noon time for lunch and then
Yeah.
go for the afternoon till say 4 o'clock.
Well, right, so what I was kind of thinking, if you did 2 hours slot for public comment in the morning, and 2 hours for public comment in the afternoon, that still gives us an hour on the other end of that, kind of dissected a little bit. Seems like that would be, particularly, you know, since we're accepting written comments as well, that ought to be a reasonable.
I just have a hard time to think we're gonna have 4 hours of public.
Well, we may not, that's the point, that's why I was curious if anybody really knows.
So,
we're all
when,
set for the room.
Great, thank you.
I say we just start public hearing and when we're done, we move into our regular business, but we do take a break.
We'll take a lunch break.
Break.
Yeah, lunch
Yeah.
break, yeah.
I do know that about 2/3 of the people on my survey said that they would be willing to testify. Whether or not they actually will show up is another question.
Don't tell them. No, it's kidding.
I'm hesitant to tell you that because now everybody else is gonna say, oh, we got 30 people coming, we gotta counteract that. No, we don't have 30 people coming.
No,
We're just basically looking for them to tell us what they're most concerned about, right?
Right, and
So-
how that concern might be addressed.
They
Just
got
get
a
some ideas.
brilliant idea, we want to hear it.
We want to hear it.
I think Steve has a comment.
Yes, I was just, we're gonna be, inviting people, but I think what I was gonna request is we talked about a couple of conflicting, laws related to ATVs and those, use of those, public easements. So if you folks have that information, if you could circulate, it'd be helpful to me so I could fully understand that before the public, you know, this meeting where the public's involved.
Fair enough.
so being at a public hearing, I mean, we can advertise this, but I would hope that there'd be some sort of structure or advice on what this is really about, because if we have 200 people show up for this thing, we're gonna have 200, this is my situation, this is my problem, and there's gonna be a lot of repetition. And Roberta, you've collected a bunch of, we're gonna hear a lot of the same thing. So is there any way, you know, it's not squelching public comment, but is there any way we can just structure, you know, tell us the situation briefly, and then what you might have for an idea for a solution? Without, because I'm afraid we're gonna start hearing the same thing over and over and over again. And most of the time will be spent on their anecdotal situation. And that really doesn't give us a lot of value.
Good point.
So I think in the public, in the advertising this, for this, we should say, here's what we want for a structure, here's what we're gonna do, or here's how you ought to prepare. Something like that.
That, and I have full faith that our chairman will kind of direct the flow of traffic on that when it's time. I think one of the ways to do that is at the very beginning, though, you mentioned,
Yeah.
if someone's already made your point,
Yeah.
don't
Yeah.
get up
Yeah.
and make the point again.
Right, we
Yeah.
want discourage repetition.
Just
is
say,
your
I agree with that one.
Yeah, right.
So we know how many there are that agree, but we don't have to hear it all over again.
But the
will be allowed to testify by Zoom?
I think we're gonna have to allow folks to.
Yeah, yeah.
So are we gonna adopt that policy at that meeting at the very beginning?
Yes.
So we're gonna let them come here, we're gonna let them go by Zoom, and we're gonna let them send written.
Right. And then we will start wading through that public comment to determine what the priorities are and then what some of the solutions might be that we might want to follow up on. And we may have to form subcommittees because there will be so many different sets of issues.
And when we come out of it, these suggestions and ideas we come up with, they're only suggestions that need to be brought to legislature to be approved, is that?
We will, yeah, we can forward some of these comments, because these are some of the issues that were raised to the private, these are major issues that were raised. These are some of the solutions that we thought, this is what the committee recommends. Okay. And we could even get as specific as drafting proposed legislation if we feel really ambitious and we have ideas that coalesce. But at least give them our recommendations.
At some point, I think it would be good to do that, because I know before there have been study groups or stakeholder groups that have come up with a lot of ideas, but no concrete language. And then the committee ends up having to form a subcommittee to try to come up with language. And then a lot of the meat of it gets lost in translation.
We'll see what we can do. It's going to be an ambitious schedule, but we'll have a fun meeting. For today,
I don't know, fun.
we'll have a busy meeting.
That's good.
We'll have a busy meeting.
One of my
here.
One of my frustrations today is that Rebecca was not here, and I really wanted to be able to toss ideas back and forth with her. And I find it very difficult to get a chance to communicate with her, because MMA only communicates with their clients, which are the towns.
Well, there'll be opportunities, I think, as we go on with this.
I hope so.
I think you can communicate directly with Rebecca though anytime you're on, right? She's willing. I think you'd be able to communicate directly with Rebecca, right? If you offline, if you wanted to.
I've tried to, and I don't seem to be able to get through to her.
To her?
Yeah.
Okay.
So for today, do we, I know that there's a member of the public on, we don't have a public comment period, but do we want to hear from members of the public who are attending? Sure. I think the person is Nars Bars,
Yeah, that's his Facebook name.
I understand.
I think they see we're talking about them. I see a smile. Here we go.
Okay, to the chair, members of the committee, I'd like to thank you for your time and the efforts you're putting into this. It's a rather confusing and long-term situation.
You provide your name and the town you're
Yes,
from?
yes, I am, the name is Thomas Maher, and I'm from Stetson. Also, as a former 28-year employee of OIT, I understand your early quandary. I have seen that many times, but in general, I'd like to make one summation on what I heard, and then maybe that'll be a comment on what you're doing. I heard that there's a lot of confusion in the public on a lot of topics, and one suggestion I'd make very easily is if a city or town makes a statement on the condition or status of a road, that they bear the burden of proof. They say the road is discontinued, show us the documents. The road has anything else, I'll sum it up just on that. They bear the burden of proof, show me. I can't prove a negative and show that it was never done. And thank you for your time.
Thank you. So, anything else that we want to raise today? Any other ideas?
I'm kind of bouncing off of what he just said. One of the suggestions that I made, is a thought that my husband came up with years ago, is that each town should have a huge map on the wall on which they indicate the status of every road that they know the status of. And a good place to start with that would be the DOT's map that they have showing all the roads that the town does maintain. If we could come up with state funding to provide each town with a map. And then over time, add to it as they find out more, maybe start with the publicly maintained roads, add on to that privately maintained roads, add on to that discontinued roads.
So every town has the access right now through their 911 addressing officer to get a map, just what you're saying,
Mhm.
that shows all roads in the town, public or private, if they've got a name on it.
I think though, I'm hearing what you're saying is almost like a mandated thing, because, you know, I work in a county with towns of varying sizes and, capacity. And I still have towns in Aroostook County that town business is conducted at the kitchen table of the first selectman, because there is no town office, and you go register your car at the house of the clerk, you know, I don't know where you put that map, because there's no focal, Gathering
No
point.
public place.
well, no. I mean, there's a few of those left, but there are some,
On the gas station.
yeah, I think there's
The
one down.
the thought was that then anybody could look at the map and know what the status of a road is, or at least know if it is or is not publicly maintained. Because the way it is now, you can go into the town office and ask, and depending on who you ask, you get different answers.
So, but you mentioned, I mean, anybody can go online, right?
Yeah.
And see
All right
whether, you know, we're all seeing the same data, so.
Yeah.
At the very least, they could post on their website somewhere that this information is available at the link. Send it.
Yeah, I
But
think,
that has
again,
all
it
the
all goes down to capacity of the community. If we're trying to do a one size fits all, it's not gonna work.
Yeah, there are 490 municipalities in the state of Maine, cities, towns, plantations, village corporations. And that's right, there are various levels of capacity. Sometimes the town clerk is doing business out of the kitchen or his kitchen. And that's the way it is.
Now, the interesting thing, my young nephew, who became a realtor, is filling out this paperwork, and I was talking to him the other day, he was on the phone. I said, "What are you doing, Patrick?" He says, "I'm trying to figure out the status of this road and who maintains it." And I said, "Well, let me show you something here." And I showed him the DOT map viewer, and he said, "Oh my God, Pete, this is gonna save me so much time. I spent so much time trying to figure out who maintains that road. You just gave me hours of free time."
Billy,
This is one of my ideas, is make that information readily available to people, so they know they can go to the website and look it up. And so they know how to go to the state library and look up, town reports, and one of the things that I'm working on again is on the Main Roadways website, is a tab on how to research a road. And I've been working on totally revamping that with more detailed instructions as to, when you get to this website, what can you do with it?
Well, I know that I had to fill out one of those disclosure forms to sell some property with a client, and I couldn't tell you what the road status was.
That's
Well,
very
I'll
cool.
show you.
Well,
That's what we're doing.
I had to put down unknown.
can you
Just
send the link out to so everybody's got it?
Yeah, sure.
So I have a question about that.
Yeah.
I don't know if it's to Jim or not, but I was looking on the website and like the Byron Road. We deal with people up in there all the time. It's a seasonal road. It's listed as a town way. So when I read the definition of a town way, it says it has to be plowed at the nearest convenience. So is there a reason why a town way wouldn't be plowed?
what you could do is close that road to winter maintenance.
So you can.
Maybe you
That's
can
right.
do that. That's right.
Okay,
Absent a closed to winter maintenance, it's supposed to be plowed and maintained,
Okay.
open.
but it has to be posted as winter maintenance. So
You would have to have an order.
Process too that you have to go
Yeah.
through to close to winter maintenance, right, including giving the public notice and all of that.
Exactly.
So the
You
DOT
said Byron?
website will tell you
it's the Byron-
if a road is
yeah, Byron
discontinued?
Road.
No, it'll tell you if it's publicly maintained.
Okay,
It'll tell you if it's a winter road.
but it could be a public easement or a town way.
Alright, maybe what I do the next, well, one of these meetings, just give you a quick 10-minute review of what map viewer does show you.
Yeah.
Because, if it's a blue road, that means the town maintains it year round. If they maintain it seasonally in the summer only, it's like orange. If they maintain it in the winter only, it's yellow or something like that. So that is usually accurate, but I'm doing reviews and inventories with towns all the time to update that, and I usually find errors because we don't do that as much as we used to. We rely on the addressing officer to keep that stuff up to date now. But first glance on most roads, it probably is gonna give you what you need.
While looking at it too, it doesn't show me my location either on there, does it? Like, if I'm running it out in the field?
You can do lat long, you can, yeah. you can
Right,
do
but it's
whatever.
it's not like, Google Earth can automatically rate you, that's what he's saying.
Don't know.
It
I don't
didn't,
think
it didn't
so.
show, when I was just asking if there was an option for that.
I don't think so, cause I know when we did the one in the Allagash, we had to literally, drill down and figure it out, but we knew where we were looking, so it worked.
Does it take into consideration those roads that are
Oh, it's that.
maintained in the summer by the state and maintained in the winter by the towns?
Yeah,
It
Those are
does.
state aid.
Okay, so that's on there too.
State highways, state aid, and townways. And it shows actually the non-maintained, which would typically be the private roads. So what you see on map viewer is a combination of what we have at DOT that came from the town, plus the whole E911 data layer. That's all the private stuff, all in one map.
And how often is that information gathered from the towns?
It's when addressing offices do their job and send that in. And it's when I sporadically do reviews with towns.
I think that last part is more accurate than the first one, from my experience. I mean, addressing officers have become more and more challenging to even find.
Yeah.
And part of the issue is that, town administrations change every few years. So, for
Yeah.
example, in, the town of Sumner, there was a road that had been graded every year for years. And they got a new road commissioner, he said, we've never graded that road. And it was taken off the DOT list, and a few years later, he's no longer in office, they've got somebody new, and he said, yeah, we've always graded that road, and I'll put it back on the list.
No one ever told me.
Consistency is a problem, I take it.
Mhm.
Well, and I think you just nailed, one of the last communities I worked for as a town manager had 5 town managers from 1942 to when I left in 2010.
Mm.
There's been more than that since I left.
Yeah.
Institutional knowledge gets lost, that kind of.
Not just, that's just the town manager, clerks change, code enforcement, I mean, it's just.
Well, the other thing too, a lot of towns are not forthcoming. I mean, you look at those, like Onyx maps that the guys use for hunt, right? A lot of towns, you get all the tax maps there, and a lot of towns, there's nothing there because they flat refuse to release it to the state.
Mm.
When you're dealing with a town like that, who knows what you have for information? And there's a fair amount of them. I unfortunately live in one, have a camp in another one, and I'm like, I can't get any information. I have to go to the town office. On their days they're open.
And then sometimes you go to the town office and they say, oh, no, we're shut down because of COVID, you can't come back here, you can't look at this. And if you ask them to do the research, they'll say, oh, good grief, that would take us hours and hours, we're not doing that. And so you send them a Freedom of Access Act request, and you've just made an enemy.
Well,
It's those days.
The map viewer on MDOT is handy. I mean, we use it a lot to the chagrin of towns because they will designate an ATV access route. And we'll go in and say, that's an MDOT road or it's state aid road, therefore, as a town, you have not the right to do that. Only MDOT can do that. And I deal with that at least once a month.
All right, so for the next meeting then, we'll deal with minutes, we'll deal with our remote policy. Pete will give us a brief rundown on the MDOT resource map.
Is this the next meeting or is the next meeting public hearing?
Well, then we'll do the public hearing. It's gonna be,
Oh, okay.
okay.
So we're gonna start at 8 o'clock now?
We're not gonna. You're gonna give us a real concise review.
I will.
We're gonna
Okay.
start with the public hearing, right? Jim?
Yeah, I mean, the remote policy will take all of 2 minutes for us to say yes. Minutes will take 2 minutes. So probably it'll be, Pete will give us a quick rundown on the MDOT tool. We'll do the public hearing. We'll prioritize. We'll come up with committees for recommendations. It's gonna be a busy meeting, but I know we all can do it. That'll be the 14th at 10. We'll get that agenda out fast so that you have a notice to give to your clientele, your constituencies. What it is we're gonna be talking about, what it is we need for public input.
So with that, Jim, shouldn't it also give some sort of guidance about what we expect to hear from
Yes.
you at the public hearing? Instead of just hearing 250 gripe sessions?
It seems to me that might be guidance you can give when you're opening the hearing, because they can
You can,
submit
but-
whatever they want in writing.
We can do both. We can
Let
say
them
that.
know ahead of time, just so they prepare something that they know. You know, we don't need a 6-page dissertation on what's happened over the last 42 years. We just need to know what's the situation, quick problem, and some ideas on the solution.
So we'll confer about that notice.
We'll work on
I
that.
looked at the Kennebec Journal and we'll figure out that time. We'll work on that. Got it.
We have homework.
I've got one logistical, sort of substantive logistical thing. We have been still collecting resumes and interviewing people for the paralegal position to staff this commission, which is obviously gonna be a really important position. I have posted it on my personal Facebook page. I've posted it on my LinkedIn page to the extent people are inclined to connect with me on either of those social media platforms. Feel free to. You can see pictures of my daughter and her horseback riding and my cats, and also share the posting, which I would really appreciate, because I think the more resources we have, the better. We're gonna need to dedicate some real
So
time.
David,
and
weren't
manpower to this.
you doing interviews right after the last meeting?
Yeah, and we had 2 good candidates withdraw their applications, so we
Oh.
have reposted it and extended it. That's why I've amplified my efforts to try to get it out.
So if you know anyone,
They get to work with me. It's a nice office. There's always candy outside the door.
You're great to work with.
you may need to upgrade to cookies.
I can do that. I can do that. No problem. Donuts, done. Yeah,
Oh, donut.
Okay.
yeah. Walks at lunchtime, like whatever. Yeah. So just to the extent that people are willing to do that, or I can send out the link and you can put it on your own social media if you're into it. Maybe you can put whatever. You don't have to be my friend. So, okay, I'll send you the link.
Not that we don't want to be your friend.
Right.
Do we
No
put it
pressure.
on LinkedIn or?
It's on my personal LinkedIn page. I just posted it today and it's on my personal
Can
Facebook
somebody access that if they're not on LinkedIn?
I
Mm,
doubt it.
Probably not.
You can see their profile, but not see the substance
Yeah.
of it. I'll send the link along with the other things I'm gonna be sending you all out, shortly.
Thank you for your help.
Sure.
Anything else for today?
Have a good Thanksgiving next week.
Next.
That's right. Everyone
Thank
have
you
a
all.
happy, healthy Thanksgiving.
Happy Thanksgiving. Motion to adjourn. Second,
Second.
all in favor?
All in favor?
Okay, we're not gonna do a roll call for.
Who moved to adjourn? I'm sorry, I missed it.
Is Steve waving or?
You did, John.
Is Steve
And who
waving?
seconded? Sorry,
Steve.
thank you.
Dave wants to say
Okay, Steve.
I would just chime me in to adjourn. That's fine with me.
Fair
Thank
enough.
you.
Thank you for your input today.
Thanks for your
Thank you.
patience. We'll get this down going forward. Thank you.
Thomas Mara.
MAHER, got it.
I got 3 of my grandsons gonna be here. There's ever. My brother was New Hampshire plans. He's
And that's helpful. It's not gonna tell you public use or town where.
No, the other thing, if you go to the county layouts.
Yeah.
You go to the links and I said directly. That it up to the county, just drive your phone to.
Went out at all.
They laid it out. Whoa, that's helpful. Yeah, you don't have to, that was, yeah, that's. A couple of years, we have decades ago, spent, we get all the county offices, they collected all of that.
Easier to get that out. It's great.
I would love to have. No way that. They set up the access, so it's all. It's one of the institutional.
Now, man.
Yeah.
No, I'm happy to.
Right.
Now.
I just, you know, like.
Yeah, totally. Yeah, I'll send it to you. I'll send it to you right now. Get them safe.
It's a generational change.
Yeah.
I mean, yeah, you think about it, Bill, there. Right.
Yeah.
All the-
Yeah, you- all-
I ever tell you that one of the best pieces of advice I have is from Richard. Calling there. We're getting that. You're not gonna be for like 6 months. I think back at how generous he was, and he's not like all of you were. And he says, you know what, like, you just take right from that. And read our manuals. It's really alive. You have the answer to your questions, right? Yeah, and that's why we, you know, it's hardwired, we're looking at people, but also it's good to try. I hear this. And so they'll be like, well, I told them maybe they told me to check in my calendar.
You're only gonna get that if it's a specific situation.
Yeah, I would only have both the general guys going to the corner here to get someone on there now, but yeah. I have to be. Well, and that's true, but I do work with, well, Andy Hart. Yeah. Yeah. Yeah, it's been, pretty good. Yeah, but, yeah, he's working in it.
I know that.
Right?
Now we gotta keep get you dead all.
I would laugh. I was leaving the store. And I would cross the county line. Exactly.
Yeah.
Especially. When I use the interstate. Yeah, so I see it. Yesterday, you guys, at my house, we had like. The oldest is a freshman, it's on his seat now. They call him. And one, yeah. So he's. I said, I understand that what you had for snow down Albertville, snow on the beginning of your.
Yeah, right. Like, you probably got a nice.
I would think so, yeah, I didn't come that.